Good morning, Mr. Cantor.
My lord, good morning.
Yes, do begin.
My lord, I'm grateful. I appear on behalf of the appellant alongside my colleagues, Tribunal, Appellant friend Miss appears on behalf of the Home Secretary. And my lord, I don't think, despite and some apologies in terms of the various authorities' bundles and the updates that have happened, I would hope that the court now has all of the papers.
Everything we need, yeah.
And we're ready to proceed.
And we've done an awful lot of pre-reading in this one, so we can probably take things relatively quickly, yeah.
In terms of a time marker, it's a dangerous submission to make. I hope to come to the end of my submissions by 12:30.
Good, thank you very much.
My lord, as you're aware, this is a challenge against the decision of Judge Kabedi, substantive judicial review refusal of the 6th of May this year. Insofar as the appellant is concerned, there are three principal questions which the court is invited to consider. The first of those, which is likely to take up the bulk of my submissions, is the question of whether Judge Kabedi reached an irrational conclusion on the question of procedural unfairness. The appellant's headline point, of course, being that the minded to refuse procedure, which was followed in light of this court's decision in Balajagari, was inadequate in this case and did not put him on notice of the various concerns that were ultimately raised in the refusal letter, which was the final pulling of the trigger in this case, with there being no right of appeal. So that's question one. Question two is then fact-centric, and I'll have a very little amount to say on that because my skeleton argument, I say, deals with the points discreetly. And the third question will be the question of whether the court is not with me on the first 2 points and the Secretary of State was entitled to reach a conclusion of dishonesty, ultimately whether it was right and lawful considerations were made as to the length of leave that was granted. Within that, and I haven't dealt with it separately within my skeleton argument, will be the substantially different point. We've referred within both Judge Kabedi's judgment and also within the pleadings to Section 31, but in reality, of course, it should be Section 16 of the 2007 Act. So with the court's leave, if I proceed on to the first question, that of procedural unfairness.
Very helpful.
The court has heard my headline point and the appellant's concerns that the refusal letter in this case was an entirely different animal to the minded to refuse letters, and there were two of them, which I'll take the court to in turn. What I want to do, and perhaps somewhat unusually, is turn up first of all the detailed grounds of defence that were drafted by counsel, not my learned friend, but Miss Hill on behalf of the Secretary of State.
Well, you can certainly do that, but the likelihood is that that's not going to change matters, because the question is, and I don't think it's a question of irrational conclusion, she's either right or wrong on procedural fairness. The question is whether the information or the allegations were put with sufficient clarity to Mr. Khan, and whether he replied. And pleading point about whether the Secretary of State's counsel, when he or she first got hold of them, got it round her neck or got the wrong linguistics, unlikely to help. It's likely to be a pleading point. But if you want to go to the detailed grounds, you go to them.
My lord, I will do so exceptionally briefly. At page 191 of the core bundle, and in particular paragraph 23, just whilst the court turns that up, if I may just read out the very short sentence in question. It is qualified and not necessarily a concession, but it's read as follows. Whilst the claimant may not have been put on notice of each and every adverse finding the Secretary of State was inclined to reach, he was given clear direction as to the tenor of her concerns and what was required to address them. Now, that, as I say, is a starting point that at least the Secretary of State accepts that the minded to refuse letters did not put each and every concern to the claimant.
No. Finding, not concern.
Indeed.
But there's a difference.
My lord, yes.
But also it's may not did not.
My lady, that's why I qualify my submission by accepting it's not a concession made by the Secretary of State. It's a far more careful observation that's been reached by counsel on that occasion. If we then fast forward to the substantive hearing itself before Judge Kabedi, very briefly, if I take the court to page 110 of the core bundle, paragraph 27, which is a run-on, it starts at 109, it's a summary of the submissions made by a different member of the bar, Mr. Smith, representing the Secretary of State. Running on to the top of page 110, there is what appears to be an acceptance that the refusal letter was...
Hold on, I don't have that. Oh, at the so take me note, so yes.
My lord, forgive me, 110
Yep.
of the court report. And it's the top, internal page numbering 9. I noticed my lord's got a separate copy of the judgment. Internal page numbering 9 at the top, as I say, summary of Mr. Smith's submissions, where he goes on to say that the refusal letter effectively was more involved, but then qualifies that by saying that the concerns that were raised in the refusal letter were not central to the Secretary of State's decision. If we now stay with Judge Kebedi's reasoning, having looked at what was said by the Secretary of State on that occasion, Judge Kebedi deals with ground 1. The reasons start at paragraph 32. Paragraph 34 is the court grappling, or the tribunal grappling with the procedural unfairness concern. And in essence, Judge Kebedi goes on to find and recite what was said by Lord Mustel in Doody of the requirement that the gist of the case against him should be provided, not that detailed reasons are given. Paragraph 35 goes on to agree with the Secretary of State in saying that in this particular case, the correspondence was such that the appellant was in fact given more than the gist of the case against him in the second minded refuse letter, and there of course is Judge Kebedi can be seen to be rejecting my submission. At the bottom of paragraph 35, or the final element of the second half, Judge Kebedi made the following point. The applicant was already aware of the respondent's...
Oh, don't miss out the previous sentence. It addressed the applicant's response to those concerns and explained why his response was not accepted as credible. Then she says the applicant was already well aware. Yeah.
My lord, yes. Now what Judge Kebedi does at paragraph 35 is to refer to the history of the communications and the decision. So, and that I have to accept is right, because there have been a string of decisions in this case, some of which have ultimately been withdrawn by consent or pre-action response. But Judge Kebedi is right to look at that history and to say, well, this is what you were told. The difficulty is, whilst it's right to look at the history of the communications and the decisions, the appellant's position will be, if we take everything in the round, and I'll briefly take the court to the relevant history of this case and the communications that Judge Kebedi refers to, but ultimately, even putting all of those elements into the pot, the interview, the tax questionnaire, the minded refusal letter and the refusals, it doesn't come close, adding everything together, to the refusal letter that ultimately came out on the 17th.
What wasn't put to him that you say should have been put to him?
My lord, a number of things. In reality, if we fast forward to the final minded to refuse letter, the Secretary of State asks for information. She asks for documents to be provided, bank statements, invoices, and the like. When those invoices are provided, in line with the Secretary of State's request, she then goes on to conduct a forensic analysis of those documents and open source checks, and we can infer from that that either checks have been conducted on a search engine and or Companies House to ascertain the veracity of those documents. The difficulty, we say, is that it stops there. There isn't then, when the Secretary of State unearths further concerns, which ultimately, as my lord says, crystallise into findings against the appellant, there isn't a further opportunity for him to respond. So in a short answer, given the time pressures of this hearing and my lord's indication of the extent of the pre-reading the court has done, it is the analysis of those additional documents that were submitted in response to the second minded to refuse letter dated the 11th of March 2021. That in particular troubles the appellant. Now, with that in mind, I'm in the court's hands. I'm more than content to very quickly take the court through the interview transcript, the tax questionnaire, ultimately leading up to the refusal letter, if that would assist. But if
well, you take us through everything that you want to take us through. We haven't got time pressures. If we don't think it's helpful, we'll let you know.
My lord, I'm grateful. I'll start off with the first in time, if I may, in that case, which is the interview that was conducted on the 7th of February 2017. That is in the supplementary bundle and starts off at page 100.
Yeah, the one unfortunate problem is, despite having two supplementary bundles, I don't have page numbers in either. But if we identify the document, I can probably work it out.
My Lord, the supplementary bundle in total, in the absence of the page numbers, runs to, I think, 105 pages, and the tax question, the tax interview,
Right at the end.
is the final document.
Yeah.
This is the one occasion on which using the electronic bundle is better
Indeed.
than using the paper bundle. The pages actually correspond, and it's easy to get there.
My Lord, I'm grateful. The tax interview is a short document of 5 pages. It starts off at page 100, both PDF and pagination numbers.
No, there are no pagination
There aren't
numbers.
any.
That is the whole point. There are no numbers. It's not that they don't coincide. They don't exist.
My Lord, I think I can only apologise.
Yeah.
I certainly have a paginated copy. I'm mystified as to why that hasn't reached.
Well, I had it attached to the original bundle. I sent it yesterday or the day before. Neither of them had. And I checked it's not me. I got somebody to look at it and say, I'm not missing something, are they? But are we dealing with a document that has on its first page the word at the very top, unclassified, combined version, 12th of March 2015? Yeah, okay.
Yes. So this was the first in time in terms of the Secretary of State conducting her inquiries. Just very briefly going through the questions, we start off with questions about immigration history. The second section, helpfully it has been subheaded by the author of the interview or the interview template, asks questions in respect of his current employment. When we then move on to what is my page 101, the second page of the interview transcript, there are questions then asked about his self-employment history, registration, when it started, number of clients, and then some engagement with, for example, at question 13, particular invoices issued to Mr. Ali and Mr. Doltside. These are all in reality questions where the appellant is being asked to provide his accountant to provide certain responses. At this point, he hasn't, first of all, this is of course pre-Balajagari, been notified of the Secretary of State's concerns. That was a pattern that troubled the Court of Appeal. When we ultimately get down to the third page, again, more questions in terms of how he's travelled, how he's paid for the work, the services he provides. Some questions then on my page 103, this is the fourth page of the transcript itself, my Lord, starting at question 20 and concluding at question 29, in respect of some of the transactions that are referred to, £1,000 going into his account and the like. The next page, question 30, we start to see some questions in respect of the use of an accountant in Birmingham despite the appellant living in Ipswich. Then we move on to, and we're familiar with this from Balajagari, questions in respect of the HMRC declarations that were made. At no point during this is there any indication you're about to be accused of having engaged in dishonest conduct.
Yeah, but this wasn't the minded to letter.
No, my Lord. But given Judge Kubedi's position of the need to look at the full history of the communications, this is the first of the documents that we have. That was then followed, just slightly earlier in terms of the pages, by the tax questionnaire. I would invite the court to look at page 70 of the...
Yeah, it's absolutely pointless to give page numbers because we haven't got them.
My Lord, I do so.
But
I
you can give them to my Lord Justice Warby.
Indeed, my Lord.
Yep, I'm using them.
Yeah, but you'll have to identify the document and give us a clue.
My Lord, it appears in terms of navigation, it's just after the letter from Marks and Marks solicitors. The actual document I'm inviting the court to consider is a tax questionnaire. It's a series of tables with bold letters that have been filled in by...
Well, I've got an index. Let's look at the index so I can try and work out where it is. And where on the index are you looking at? 19.
It's item 19.
Right, so it's immediately before the tax interview then. Yeah.
Now, item 19, the tax
And
questionnaire...
is it a document that begins, thank you for submitting an application for indefinite leave?
My Lord, yes.
Yeah, okay.
Does that document itself have a date? And the covering letter?
It's 28th of May, my Lord,
does.
2018.
Right. Yes.
Well, it's signed by the appellant on the 19th of June 2018, if you go to the last page.
My lady, yes, it appears twice in the bundle, once as the blank questionnaire that was sent out, and secondly as the completed version.
Well, what matters is the completed version, surely.
The version you just took me to is an unsigned version. Is there a signed version then?
My lord, there is. It starts at... It's item
Yes,
18, starts at page 69.
Right. You put in a supplementary bundle. I think you might even have needed permission for that. You put in two versions. None of them have got page numbers. They're 105 pages long. You've taken me wasting a lot of time to one, which is unsigned. And are you now trying to take me to another one that is signed by reference to a page number that doesn't exist? It's not very helpful to this court, and it's very irritating for the court, I'm afraid. And it's unproductive of time, and it doesn't help your client because we're no longer focusing on the subject matter. We're focused on where on earth is this document. But think of us, with the exception of Lord Justice Warby, not having a clue about what you're talking about at the moment, and try and help us. You've taken me to a document towards the end of a tab, an unpaginated tab, which isn't paginated. My lord. Are you trying to take me to another document?
My lord, yes. As I say, the questionnaire appears twice, and in reality, I'm content for the court to consider either, because it's not the answers that I'm necessarily inclined to invite the court to consider, it's the questions. My apologies for the bundle. I'm mystified as to why that appears as it does. Certainly, I think
I can give you one bundle back, and you can see what we're working with, because I've got them twice.
I've no doubt.
I would guess that what's happened is that it's been photocopied in a way that's cut off the bottom of the photocopy with the original, because quite a lot of the text is also missing.
My lord, as I say, I can only offer my apologies.
Well, because you put it in, you've got to try and deal with it as well as you can, but you can see why it just doesn't help your client or the court to have documents that you can't track down. Anyway, I've got one, at the moment, I'm still towards the end of a half photocopied tab of documents, and you say it's the 28th of the 5th, and my lady said it's a different date on the signed copy. Yeah.
My lord, yes, the cover letter from the Secretary of State is dated the 28th of May, so that's around about the time it would have been authored and sent to the appellant. It was then signed in line with what my lady has indicated on the 19th of June by the appellant completing that document. If my lord has that, I can describe the contents of it. It's a pro forma questionnaire, no different to those that were seen by the Fourth Appeal in Balachgara. It is another short document. It isn't a document that in reality engages with anything. It asks him questions, first of all, the nature of his business, to which he says self-employed, the years in which he was self-employed, and moving then on to whether his self-employed tax returns were submitted by him himself or by a firm of accountants. What is missing again from this, and I can make the submission briefly, is in effect any real engagement with the substance of the case. This is basically the Secretary of State inviting the appellant to put forward information, which we know from Balachgara, and I'll turn to Balachgara in more detail during the course of my submissions, was deemed not to be sufficient because there was no forewarning. Questions 13 and 14 ask him about whether he was satisfied with his tax returns, and
my copy is blank.
My lord, you may still be at, and it's entirely my fault, at tab 19. Tab 18 is the completed version. And what he does, it doesn't necessarily provide a great deal of light, my lord, because all tab 19 really seems to say is, please look at the letter that's been provided by my accountant. So there's not a great deal of meaning.
If I go to the pages before, I've got accountant's letters. This is hopeless, and I've got tax forms. Are you saying I should have a form like the one we've just looked at, which has got answers?
My lord, yes. Perhaps if we just very briefly...
Well, I haven't got that. The bundle that you're working from is simply different. You sent me a second bundle. Is it in that one, perhaps? I've got two supplementary bundles.
Let's see if I can find it, because I've put it in my bundle. No,
No, it's not.
you need to get back further. But you've just gone past it.
Oh, here.
There it is.
Okay. Thank you. My lady has found it, but it's not at the moment helpful. We go through history, and it really isn't helpful, I'm afraid. We do huge amounts of pre-reading, and I've read much of this in the two forms we've got. They're the same. But it just doesn't help if you're only photocopying part and if you've only got some page numbers. But you know that and you've apologised. But for future cases...
I'll only repeat my apologies very briefly, my lord.
Right.
As I say, questions 13 and 14 ask him about whether he was satisfied with the contents of his tax returns, and then whether any corrections or resubmissions were required, with reasons why. But we're still not at a stage where there's been any engagement or any real enlightenment.
It might be convenient, just because he mentions his accountant letter dated 12th of June 2018, just to turn that up. It's in the second supplementary bundle, page 91.
My lord, my lady, yes, and my lord Justice Lewis.
I've got it.
Because many of the answers to the questions on this form rely on that letter, so I think it's quite useful for us perhaps just to look at that letter and see exactly what it
The
does
12th
and
of June
doesn't say.
2018, is it?
That's
Yep.
That's page 91, isn't it?
Page 91.
it is.
Yes. Well, before we go there, can I just ask this? My lord and my lady won't be able to follow, possibly, but at page 76, page 76 of the bundle, there's an additional information page that appears to be part of the responses that otherwise end at page 75. So what I've got at page 75 is the answers signed off by Mr. Khan on the 19th of June 2018. At page 76, additional information where he says, please see letter from Marks and Marks dated 20th of June 2018. Now, we're just about to go to a letter dated the 12th of June 2018. Is there a letter of the 20th of June, or is that some form of error?
My lord, there is a letter at page 69 from Marks and Marks dated the 20th of June 2018.
Right.
Again, my apologies to Lord Justice Lewis for the state of the bundle. But,
It's not the state of the bundle. I mean, I can't follow what you're saying because I've no idea what you're talking about.
I see. Well, that's the covering letter. Oddly dated the day after the form is signed off, but anyway, that's the covering letter. Yeah.
My lord, yes, and in reality,
that's the letter at page 69.
yes, and for benefit of Lord Justice Lewis, that simply sets out the documents that were submitted on that occasion in support of the response to the mandatory to the tax question.
Letter of the 12th of June, then, please.
The letter of the 12th of June, which I think from memory is the letter that was provided by SAB accountants, is
The first of two letters they provided.
it is, my lady, and it's page 91 of the bundle. Simply sets out that they confirm they act as accountants for Mr. Khan. The tax return for the year, the 5th of April 2013, was filed incorrectly due to an internal error. It describes that error as being a formula within the spreadsheet that was used to prepare the return, containing an error which affected the calculation. Describes in very short terms that the return was then rectified and filed with HMRC to correct the position.
What does that mean? I mean, I still don't know, having read all these pages, what the error was.
My lord, I don't think we take it much further than, and of course we're in the hands of the accountant to describe the position. The two letters they've provided, the other being dated the 3rd of January 2020.
Well, that does go into a bit more detail, doesn't it?
Indeed, my lady, and but for those who have page numbering, it's page 45 of the supplementary bundle, item 7. It again repeats the position of there being an internal error. It then goes on to say that the firm did not prepare a bank analysis to conduct a final check on the total income.
Is this a letter of the 3rd of January?
Yeah.
It is, my lord, 2020.
So we did not prepare the bank analysis to conduct a final check on the total income, as we do not do this work for all self-assessments. The bank analysis would have fixed this error at the time. However, neither us nor our client did this intentionally. So that is potentially a somewhat different or more expansive explanation than the explanation that's given in June 2018.
My lady, yes, we'd certainly say it's an expansion of the earlier letter.
Well, I still don't know what the error was, the initial error. That's the first thing. The reason was due to an internal spreadsheet error. I don't know what that is, whether the information provided was wrong, whether their employee typed in a wrong figure or what, or how it is that an accountant makes an error. And then it says there would have been a way of checking the error if they conducted a bank analysis, but they didn't.
Well, my lord, that is, of course, the content of the letter, and that is all I can assist the court with insofar as Savinco is concerned. I will briefly, just at this point, turn over to the second part.
It is a bit difficult to understand. I mean, my command of Excel is not great, but I do know that it uses formulae, and you put in the sum that you want to generate by reference to cells in the spreadsheet, and it's pretty straightforward. Even I can do that. It's very difficult to understand how that sort of error would occur in a simple calculation of this kind and generate a figure that was less than a third of the true figure. And that's why it's odd that twice that he's been asked to explain it, and the accountant's been asked to explain it, and there's been no explanation.
My lord, I take that point on board, and one can speculate as to what may have happened, but that isn't going to assist the court.
But that's not an area where he's been treated unfairly in any way, is it? He's been told exactly what's wanted, and he has failed to produce the information at all.
Can I ask a further question arising out of the second paragraph of the second accountant's letter? And it's this. The appellant said in response to the second minded to refuse letter that many of the payments he received were received in cash. Now, how would the bank analysis have picked those up?
I may need to go back and look at the precise wording, my lady, but yes, I do accept that it was received in cash. Whether that cash was then deposited into the bank account as a deposit that the accountants would either have seen or queried to ascertain whether it was from self-employed income or other sources would perhaps be how bank analysis would identify those.
So only if those precise sums had been deposited as cash in the account?
My lady, yes.
Okay.
And insofar as my Lord Justice Warby's point is concerned, I take on board the court's position as to the simplicity of Excel, but of course...
Well, we don't know whether it was Excel, they don't tell us that.
Well,
it may have been QuickBooks or something else, I don't know.
It could well have been...
I've seen the adverts. I have used Excel.
It's the time of year where they certainly ramp up their advertising campaign in any event. But my Lord, it isn't ultimately foolproof. It is software that does rely on data input from individuals, and if there has been an error,
It'd be
which we
interesting to
don't
know
know,
whose error it was. We didn't get the right figures to put in because Mr. Khan didn't give them to us, or our accountant, Mr. Page, out and forgot to put in to the columns 2 months.
And it's a very heavily qualified explanation because one goes over the page to the second page of the January 2020 letter. One sees two types of qualifications expressed by the accountants on that page.
my lady, yes, and the qualifications have evolved or changed over time. The 2018 letter accepted no responsibility at all.
Yeah.
The 2020 letter changes that by saying that the responsibility is only accepted towards the appellant and no other individual or entity.
It also says we base our opinion on the information, explanations, and records provided by the client. The reference is being issued on the client-specific request.
My lord, I take that on board, but
So they're only doing or reaching opinions on the basis of the information provided by the client. So even though they don't say what the error is ultimately, they're only doing what the client is telling them to do, it seems.
If we read this as a statutory instrument, we are in difficulty in terms of the language used, but of course this isn't a statutory instrument. And
I was just reading it as a letter, and I read the words, we base our opinion on the information, explanation, and records provided by the client. And I read it as meaning we base our opinion on the information, explanations, and records provided by the client.
My lord, yes, and those certainly are the words used. Yeah. What I would invite the court to do is to read the letter as a whole. Now, if we look at the nature of that letter and the explanations that are given, the court may have views as to the depth and detail that's contained within them. But notwithstanding the what some may call boilerplate clauses that have been quite common in cases of this nature, it does appear to, in my respectful submission, to be clear that the explanations provided, detailed or not, do appear to be coming from the accountant. And if we look at the nature of the relationship, where the accountant has been instructed to prepare these tax returns, he or she is in the position to provide the information that is contained within that letter. So
If the error was the accountant's error, they'd have said so. So the error on the spreadsheet must have come from the client.
it was a spreadsheet that, as I read the letter, was prepared by the accountants, or certainly, well, that's how I read the letter. It's an error, a spreadsheet that's been prepared by the accountants. And also, my lord,
the income was understated in the return. The reason for the understated income was due to an internal spreadsheet error. That tells me nothing about were the wrong figures put in by the accountant, was a column left out by the accountant. And all I know, if I read the rest of the letter, is that everything that's been done has been based on the information, explanation and records provided by the individual. It just doesn't tell me anything that says the accountant himself made a mistake, which the individual didn't check. Anyway, we don't want to spend time with this. We're not the first instance court.
No.
We're not the Inland Revenue or the Secretary of State who's the decision maker. You're taking us to this really to show, you were taking us to documents to show that things weren't put to Mr. Khan. And we've got that point here.
If I may briefly just respond to the two concerns my lord had in terms of the letter. To simply say, I appreciate this court is not making first instance findings of any nature. One would expect in a letter that has been drafted in the way that it has, if the error originated from the appellant as opposed to the accountant, it would be said in those terms. In addition to that, again, looking at the nature of the letter, the third paragraph right from the bottom of page 45, so this is the substance of the 3rd of January letter, concludes by saying we did not charge a fee for the revised work and we charged a minimum fee as a gesture of goodwill, or as a good gesture as it's put. Inferences have to be drawn, but in my submission they are reasonable inferences that this all points to an error that's made by the accountant. I'll leave that there.
Yeah.
If I may go back to my original path of just going through where we stand. So we've been through the tax questionnaire and some of the material that was provided. The next event in time was then the refusal of the 14th of February 2019. This, of course, again forming part of Judge Kabedi's basket of evidence that she said needed to be considered when looking at what was put to the appellant. That is at page 62, and insofar as it may help, that is item 17 on the index. In brief, my lord, I'm sure the court has already had sight of this as one of the decisions that was made. It doesn't really add a great deal to what we'd expect. It begins by thanking him for the application for indefinite leave. In terms of the consideration, that doesn't start until page 65. It does, in my submission, two things. It identifies the 42,000 odd pounds that he declared in his 2013 application for leave to remain. It then goes on to outline the checks that were conducted with HMRC, where the tax return indicated a declaration of self-employment of 12,870. Talks about the consequences of that, the concerns.
Are you reading the letter of the 24th of the 18th? 24th of May 18th?
No, my lord. This is the refusal letter of the 14th of February 2019.
Then I'm really sorry, but you're going to have to give me more time to locate it. So which item is it? I thought you said 17.
Item
So
17.
it's back. It's back about 3 or 4 pages from the tax questionnaire that we were looking at.
Yeah, it is item 17. I thought it was. This is really pretty hopeless, Mr. Gadger.
My lord, you'll be pleased to hear that we will soon be moving away from the...
Not yet, because I haven't even located that. Anyway, you tell me what's in it.
In essence, as I say, it identifies the discretionary figures that were given. It references what was said in the tax questionnaire, but that is of no material event for the purpose of this submission. It, in terms of reasoning, doesn't find it credible that the appellant reviewed 2 different firms of accountants, Sab & Co. And Hayes Chartered Accountants. Or it it doesn't also accept as credible that the accountant would submit a return that contains significantly different figures, or alternatively that the appellant would not have identified this. So this is as far as this letter goes. We then have...
It does add that the income originally declared would have accumulated 0 points.
My lord, yes, my point about the
There's
consequences of the under-declaration, yes. Either that you're not...
What about possible motivation?
So insofar as the HMRC point is concerned, yes, he's been notified from a relatively early stage of the discrepant figures and the Secretary of State's concerns. That, of
He's
course...
also told that the Secretary of State doesn't find it credible that he wouldn't have checked his own tax return before it was submitted.
My lady, yes.
Nor would you, nor your accountant noticed an error that had been made when you received your tax bill with a low amount that you would be expected for the income you earned.
My lady, yes. So this is all part of page 67 and the concerns in respect of his knowledge and his actions.
Consideration has also been given to the timing of the amended tax return. Amended tax return 3 months before applying for ILR.
My lady,
Taking
yes.
into account the above information, I've not found the error made in your tax return was a genuine error.
My lady, yes. And insofar as that element of the refusal is concerned, we of course see that as being sustained up until the decision under challenge in 2021.
That's a consistent thread in the Secretary of State's reasoning, isn't it?
There's no surprise when it comes to this element. What we know, of course, is that this was subsequently withdrawn, perhaps in light of the Secretary of State's position in Balajagari, and led to the first of 2 minded to refuse letters. And then that's, I hasten to point to page again, but it's 41 to 43 of the supplementary. Item 6, my lord.
The letter dated the 23rd of January 2020.
My lady, yes. Now, in a bit...
Are they not in the core bundle as well? Because some of these I'm sure I've read in the core bundle.
No, my lord.
These are not, okay.
These are not, but the most recent...
You carry on and I'll count up to 41 and catch up with you.
Again, it may not assist, but this is just before. This is the item that precedes the 3rd of January Sab & Co letter, my lord.
The 3rd of January?
A letter from Sab & Co that was...
Oh, right, okay, then I have got that. That's easy, yep. Yep, 23rd of January, got it.
I'm going to be brief.
And just remind me, this was the first minded to refuse letter, yep.
This was the first minded to refuse letter. And it is, to a great extent, simply a rehash of the original refusal. It adds some points. For example, the concern at the top of page 42, that's in
the starting point is, in the first 3 paragraphs, it says, in no uncertain terms, I believe you provided false information about your income. It tells you, I think you've lied about your income.
Yes. And that I accept, my lord. But in terms of the warning, my submissions in terms of the authorities will be that more was required than what is contained in terms of substance. At the top of page 42, the concerns that we start to see added, and I'm not going to go through everything because the court is fully cognizant of the content of the letter. The new material that previously hasn't featured includes the failure to include within his tax return the £3,651 of PAYE income.
Yeah, and what's the answer to that? Because he didn't.
I'll come on to that in my second submission, if I may, my lord. But in reality, we're going to say that notwithstanding my learned friend's position on it, is relatively immaterial because that would have been taxed at source.
No, that's not the point. You're supposed to put all your income, and if you look at the tax forms that he's put out, there's a heading self-employment and there's a heading tax, total income. And the duty is to tell them your income. It can be relevant for other things. As it happens on the figures, it wasn't relevant to child benefit, for example, but it could be relevant, for example, to other calculations. And you don't pick and choose what you put on your tax form. You put what you're supposed to, don't you?
My lord, I cannot argue with that at all. The tax
so you should have done it. It's not immaterial. It's not irrelevant. He's under a duty to declare it, and he didn't.
It is something that we say is... It's not declared, and that is correct. It's also correct that the tax return forms, and I'm familiar with filling them out myself, does have questions about various sources of income, not just self-employment. the point is that it is, in this particular case, of no consequence, and that will be a question.
Well, it depends.
especially for-
The figures may not result in a different level of tax being paid, but it does have this consequence. If he's not complying with all the things, that's another iffy issue to do with the tax return, isn't it? You can't rely on the document, even now.
Well, my lord, the way the appellant would put it, and again, this touches, I'll deal with it now, but
Yeah.
it was for the purpose of submission too, is that the Secretary of State has to establish motive, that the dishonesty element of it must have some advantage to the appellant in the context of a case on the facts such as these. There's no, as far as we are aware, beyond speculation, financial advantage that flows from the failure to declare.
Not unless he puts in a new tax return with different figures again. Anyway, we've got that. It's not enough to say it doesn't matter. It does matter. It's his duty. He's a person who's required to fill out the tax return, and he didn't. And the tax return, for that reason alone, is not correct.
Its accuracy, my lord, is not in dispute, and we know that even before we get here from Sam Coast's letter, or Sab and Sab.
But even after he puts in the correction, it's not correct. It's never been correct. Yeah. Anyway.
If I may come back to the minded to refuse letter, there are then, again within that, concerns about why it is that he's amended or varied his application from one that was a Tier 1 general application to the indefinite leave route through paragraph 276B on the grounds of continuous residence. We then...
So is the difference between, this is just a question for information, is the difference between getting ILR under the Tier 1 general migrant route and under the long residence route that you only have to have lived in the UK for 5 years under the first?
My lady, yes, I think that's the substance of the difference is that.
Right, well, I just wanted to check that I'd understood that correctly. Thank you.
What pre-Balajigari had been understood of the difference between the applications, which is why they are often preferred under paragraph 276B, is 276B involves Article 8 considerations where a refusal generates a right of appeal. That ultimately, of course, doesn't happen in this case because limited or discretionary leave was granted despite the refusal of indefinite leave.
I see. So that two material differences in the two routes. That's very helpful.
Pre-Balajigari, that was the perceived position. The Secretary of State now engages with Article 8 on the Tier 1 general route, and generally experience has been that those who remained on the Tier 1 general route as opposed to making a variation were given a right of appeal if their applications were refused without some form of leave.
When you're on this, what the Secretary says, I believe you've acted dishonestly. She then comments on various things that he has said, because we don't spend too much time going through the history. We really aren't a first instance tribunal. And given that you've tripled the time because we can't even get to the documents, focus on it. I believe you've acted dishonestly. She says, I don't believe some of the explanations that you've given. And then she says in the big paragraph on the third page of the letter, please provide an explanation for this discrepancy, i.e. between the inland revenue figures and the Home Office figures, and please provide supporting documentation. So she's saying, what you've said so far isn't enough. I've looked at it, I just don't believe it. Please provide an explanation.
Well, yes. And there we are. That is the sum total.
Yeah.
That summary, I couldn't better it, my lord, in terms of the content of that letter. That then led to a response, but ultimately a refusal on the 22nd of July 2020. That is, in terms of pages 18 to 23 of the supplementary bundle, item number 4, my lord. It is...
22nd of July? 22nd of July?
It is.
I've got it then, yeah. So this is what now?
This is
the second minded to or the second decision letter?
This is
the
the second
decision letter.
The first one having been withdrawn, the second
Yeah.
refusal letter. Ultimately, this too went on to be withdrawn.
Yeah.
The appellant's position would be that, again, this is no more than a slight advancement from the material that we've previously seen. A lot of this, especially up until halfway through page 20, is really just a copy and paste of material that we're already aware of. It goes on to identify that on the balance of probabilities, the Secretary of State concluded the false representations have been made, and then it engages with page 21. The
Well,
appellant
give me the first paragraph, because you know I haven't got page numbers.
internal page 4 of 6, my lord.
I haven't even got internal page numbers.
It starts off, it's in the middle of the paragraph at the top of page 4 of 6, is considered you were able to spot the errors.
Yeah, okay.
So this is the page where the Secretary of State, and indeed to be fair, at the bottom of the previous page, which talks about the qualifications and his explanation that his qualifications didn't gear him up to spot the errors being inadequate.
Mm-hmm.
She then, the Secretary of State that is, goes through and deals with the appellant's explanations and, in summary, concludes that the spreadsheet error, the fact the accountants were busy, were not credible explanations.
The fact that you didn't check, the fact that it was understated by such a large amount,
the
timing, all of those are reasons why she thinks he's dishonest.
My lord, yes.
Timing of the amendment.
So we move on to the responsibility point at the middle of page 4 of 6. And we've talked of course, the trends that have been identified within the Tier 1 general cohort, and the Secretary of State concluding that he couldn't identify a plausible reason for the discrepancy. That, as I say, if I can move on as swiftly as possible, is the 22nd of July letter. We know from the history that this was ultimately withdrawn. Judicial review proceedings were started, but the Secretary of State responded to a pre-action letter and withdrew, agreeing to reconsider on the second occasion. Finally, my lord, in terms of my lady, in terms of the minded to refuse correspondence, we now have the core bundle.
Yeah.
And my lord, I hope that
I've got page numbers in there, 400 of them, yeah.
it's at 401.
Got more than 400, because I've even got that. Yep, great, we're making progress. Got it, 11th of March.
I'll take court through this briefly. Again, a lot of this letter is a rehash of the previous minded to refuse letter, and indeed the 22nd of July refusal from 2020. So these have both been put
Well, that's not
together.
surprising, is it?
No,
Because, the core allegation throughout has been the same.
No, my lady, but
There's this discrepancy, and I think you've been dishonest.
no,
It's as simple as that, isn't it?
it is, and that's not where the criticism lies. For the Secretary of State to have put those together is not what I seek to criticise. But ultimately, this minded to refuse letter, as I say, is an amalgamation of the points and some of the comments.
Well, if you look at 402, the allegation is conveyed to him in the first full paragraph. I believe that you have provided false information about your income to the United Kingdom government. That's what she says. You've falsely told us your income. And then she says what it is. You were telling us, the Home Office, you had 42,000, but in fact, when you look at what you told the Inland Revenue, 12,800.
My lord, yes, and that
And
is
this she's saying you're lying to us. That's what the allegation is.
Yes.
Yeah.
yes, and by this point, that is no surprise.
Yeah.
We're fully cognizant of the Secretary of State's concerns
Yeah.
from previous material. 405, and flowing on to 407, is really the request for documents and the request for information. It's clear what's asked for: invoices, bank statements, along with detailed explanations of various elements, including compliance, where he conducted his business, and the like. There is then, bottom of 405, again, additional material that's sought for different
But
tax
she
years.
says, we think you're up to no good at page 404. We think you've deliberately amended your self-employment income to hide the discrepancy.
Indeed.
And she wants all the documentary evidence about everything that explains his tax affairs, basically.
Indeed.
She says, you're lying. You prove to me. You give me the documents. You give me the details. That's what she's saying in this letter. Isn't it?
That's entirely correct. And so the documents are requested. What we then have, of course, after that is the documents are provided, and ultimately the letter of the 17th of April, which starts its appellant's life at page 262 of the document.
Yeah. Well, he then does provide lots of information, the invoices and so on that we've seen, and everything else. And this is what the Secretary says, having been given such information as your client provided following that letter saying, we think you're lying, you prove everything.
My Lord, yes. And when it ultimately comes to her findings on the 17th of April 2021, the reasons start at page 264. Up until in reality we get to 269. This is all material that we are familiar with. This is all derived, and again, not a criticism or a surprise at all, from the previous refusal letter. But from 269 onwards, and conscious of the fact that the court has undoubtedly read this letter, given its central importance to this case, I'll say it in these terms. What the Secretary of State does from here onwards is to conduct a forensic analysis, as I said at the beginning of my submissions, of the material that had been provided. She reaches a number of conclusions, concerns about the pricing structure for what she says is the same work charged at different prices, concerns about, in some elements, what is said to be the lack of detail provided in response to her questions, transactions that were made within his bank, with an allegation that there had been money in circulation, and the location and identity of some of his clients. That is what the appellant says is material that was not, concerns, forgive me, that were not put to him before the findings were made. That is
the question is really comes down to this. Is this her response to the evidence that you submitted showing that you weren't dishonest? Or is it fresh allegations which he needs to have the opportunity to answer? It's as simple as that. If it's her analysis, I've read your explanation, I don't believe it for these reasons, does she have to go back and say, I don't believe the answers you've given me, please comment further on the answers you've given? Or are these new allegations, well, I didn't realise this, but not only are you dishonest because of this, this and this, you're dishonest much more widely.
My Lord. The appellant's position would be that these are...
But is that the question that we've got to ask, really?
Indeed.
It is.
These are new allegations which he has not had adequate, or indeed we would say any notice of. The reason the appellant would say they are new is because the Secretary of State has gone away and conducted her own research and investigation. She's been on Companies House, she's been on the website, she's on top of that looked through these invoices, which I might add are invoices that she of course has previously been furnished with. She would have needed to have been satisfied on balance at that time, perhaps unaware, as we know from the litigation history in Balajagari, of the issues with HMRC in the cohort, that she would have been furnished with this material, satisfied herself that the appellant's income was as claimed at the time, and granted leave to remain as she did. But these are new allegations that are underpinned by new analysis and new work that has been conducted after the final minded to refuse response. Now, if this refusal letter were not the end of the litigation, if there were a right of appeal, there'd be no problem, because the appellant would get notice and he'd have a final shot at clearing his name, because he could put himself in front of a first-tier tribunal and advance an innocent explanation to the concerns that were raised. But this is where this stops. There's no opportunity thereafter. In reality, pre-action response is not, the pre-action letter is not the mechanism to advance further explanations, nor is the judicial review claim, because Judge Kabedi is not the final decision maker, and ultimately, of course, nor is this court. So that's where the position stops. And the appellant's point is no adequate notice has been provided of the Secretary of State's concerns, and this is out with the authorities and the guidance insofar as the question of procedural.
Can we just take one example? I've just picked one at random. If the issue is this her comment on your explanation of a charge notified to him, or is it a fresh allegation? I've just picked A1 Texel at page 269 at random, and we've got the invoices. You invoice the companies a total of 34,000.
Sorry, which page?
269
Thank you.
at the bottom.
Yep, got it.
They are companies. The invoices that he provided show that done security work for them. And over the page 270, it says there's no evidence of travel, and that had been asked for you. And if you look at the addresses, he's in Ipswich, and I think this was in Manchester. Paid by cash, doesn't find it credible that a security company would pay their invoices in cash. And then from those factors, the Secretary of State finds the balance of probabilities that your declared earnings from this company were not genuine. This is because you claim to be paid in cash by your security resources. You failed to provide an explanation relating to the nature of the work. And you say you're working from home, and don't forget he's already said there's no travel, and so on. Your explanations don't match your invoices. What's wrong with that then? Or is that one all right?
Well, my lord, that particular one isn't one that I've focused on for the purpose of my submissions. But,
but that's almost enough, isn't it? That's £30,000.
Yeah, and then that means you would have scored no points, no point. So he's had it then. I mean, that's not a new allegation, is it?
Well, if we look at the way that the Secretary of State makes these points, the appellant would say that they are new allegations. First of all, just going back to the bottom of 269 in the paragraph that my lord began by touching upon, open source searches have found websites for these companies, and including on Companies House.
So he's right. They are companies, and she's not saying they're wrong. She's not saying who are these people, and he's not saying they're sole traders married and living together. These are companies, and the problem isn't that there are companies. If she'd never made the searches which confirmed what he said and assumed it was true, it's fine. But it's the substance, really, of the cash payments, the fact that they're for large amounts of money and he's supposed to be providing services in Manchester. She's asked for travel receipts and they aren't there. That seems to be just taking... I just took that at random as it happened. That one seems just to be... comment on... Your explanations don't match.
My submission, my lord, would be that it does go further than that. At the top of 270, one of the concerns appears to be that there were regular monthly invoices for the same work listed, but the amount varies each time. Well, that is new. First of all, this is material, as I say, the Secretary of State has previously been furnished with. He's not been put on notice that there are concerns about the amount that was charged, which is a concern that features throughout the refusal letter. And an explanation could well have been provided. And I won't take up the court's time by providing examples, and then he goes on to provide an example. But of course, lawyers charge different amounts of work for the same kind of hearing. It will depend on a number of circumstances, the relationship with the client, potentially how much they can afford. Discounts are often given, the longevity of a relationship. Businesses don't work in the way that the Secretary of State sees.
But is she really saying in relation to this company, it's because the amounts varied, I think you're lying, or is it because of all the other things she said?
Well,
the reason why the responses was not found credible, really following the next... I mean, we can argue about it, but I mean, ultimately it's a matter for us to read it. But your submission is there are new allegations. I picked one at random, and you say, what, the new allegation is the bit at the top of 270 about the variable amount, and that materially influenced the decision, and even that is flawed.
Well, also, it's not just that, it's also the mode of payment. You know, the Secretary of State jumps on the fact that cash payments are made without again giving the appellant the opportunity to really explain. But
this was the appellant's explanation.
Yes.
Because there aren't traces of all these payments in his bank statement.
Yes.
So he has to explain, well, I've been paid by cash. And the Secretary of State just goes on to say, well, that's your explanation. I don't find it credible because I don't think a security company would pay invoices in cash.
And it's that final point, my lady. Now, of course, the Secretary of State...
what is he going to say?
He's going to say they did.
He's just going to say, well, on this occasion, on these many occasions, they did accept payment in cash, despite the fact the invoices invited payment by cheque or bank transfer.
I'll stray as far as I possibly can giving evidence, but certainly the appellant would be in a position to say, well, actually, industry, the way this industry works is that cash payments are.
Well, why didn't you say that then? He knew that the Secretary of State was worried about the genuineness of the payment, Please provide your invoices to evidence that you genuinely earned the money. Please provide your business bank statements to demonstrate you were paid. Please provide a breakdown of who your clients were during this claim, what their businesses were called, and a detailed explanation. Please provide travel details. Please provide your self-employed accounts. Please evidence payments made for expenses. What was the nature of your self-employed? How did you advertise and obtain new clients? I mean, there were quite a lot of questions asked.
Indeed. Well, my lord, the appellant's position would be that those questions invite material and explanations, or invite, I'll put it a different way, they invite documentary evidence and information.
Those questions were asked because she'd already said, I think you're lying. I think you're giving us false information. And then she says, give us the lot. What she's saying is, prove it.
My lord, yes. And that certainly is how a court is reading the minded refuse letter. But insofar as the appellant's subjective position is concerned, he is not, despite what is said and even reading the minded refuse letter as a whole, in my submission, rationally capable of being read in the position to understand that the Secretary of State is going to have concerns about something that he considers to be the norm in the industry. It is to a certain extent self-destructive. If I don't know that something I have done is wrong, I'm not going to volunteer that as a piece of information. And will say that the authorities support that position, including both Doody and Balashigari. But that is one example, but as I say, and I've tried to summarise it as briefly as I can, there are concerns about the nature of this refusal letter and the scope of the reasons that were given. The appellant invites the court to find that this isn't a case where these are peripheral reasons that simply don't matter. The Secretary of State has been through a string of litigation with this. 2 judicial reviews were issued. One, as I say, there was confusion around its timing, but ultimately we've had the February 2019 letter withdrawn, followed by a minded refuse letter, the July 2020 letter withdrawn, followed by a minded refuse letter, and ultimately what clearly has been a considerable amount of time, resources and effort spent on researching the appellant's documents and what can be found on the internet.
Very differently, the one thing he knows, because he had been told it time and time again, and by Supreme Council, that what the Secretary of State is worried about is he's lying. And he's got to show that he's not lying. So it's a bit odd then when he provides invoices. The next one I just happened to look at by chance is paralegal and business services, and they too paid by cash. But that apparently isn't an industry standard. And, that's why I think, arguably, Judge Kabida was saying, look at everything. Look at everything. These invoices didn't come out of the blue. He was told, we think you're lying. Give us everything. Show us you're not.
My lord,
and he gives them everything. And she says, well, this is jolly odd. They're all in cash. None of the evidence I've asked about is given. I don't think this does prove you're not lying to me. I think it proves that you are lying to me. And you say that's wrong.
Well, my lord, the fact the invoices don't come out of the blue to a certain extent cuts both ways. As we say, it cuts in detriment of the Secretary of State's case, because as we say, this is material she's already had. Yes, she's requesting it again. I accept that point. My headline submission stands that there is simply not enough.
What you say, simply say, given the nature of the conclusions that we reached, they really involve new matters which she had found out from her own investigations, and she should, in fairness, have put them to him before she reached a final decision. That, in a nutshell, is your case, really, isn't it?
Yeah. My lord, yes. Now, there are a number of authorities that both parties rely on. If I can take the court through those, starting with what I hope has been 2 volumes, volume 1 of the authority bundle.
We find on bundles, even page numbers, Mr. Gadger, so we huge progress, yes.
The first case, the natural position to start, of course, is Doody, Mustill's judgment, and his reasoning and his speech requires no introduction insofar as the guidance is concerned. But there are elements of this case which, in my submission, support the appellant's claim and undermine the safety of Judge Kabidi's conclusion that he should have anticipated the Secretary of State's concern. Now, bar 1 or 2, the authorities the court will be referred to are not on all fours insofar as the factual scenario is concerned, and I accept that. Doobie, of course, as we know, involved prisoners serving mandatory life sentences who were really dealing with the calculation of the initial tariff of their sentence. The procedural fairness or unfairness point that was made in those circumstances was firstly whether they should be entitled to make representations, and secondly the element of what they should be told before those representations are advanced. If I can take the court to, and this is page 242 of the authorities bundle,
Yeah.
and it's paragraphs E and F, E to G, sorry, that deal with this point. In summary, the argument that was made by the Secretary of State, I think it was Lord Pannick at the time who made the point, was that since the prisoner already knows the circumstances of this offence, in light of which the trial judge has made the recommendation of the penal element, he can deduce without the need for any more information both the factual basis of the Secretary of State's decision and the intellectual reasons why the penal sentence was fixed at a particular term of years. This did not find favour with Lord Mustill, who, of course, on the facts doesn't dispute that the primary materials were known to the particular offender. But what he didn't know, as Lord Mustill points out, is what the judge or the Home Secretary made of those facts, or indeed the materials that were put. If we tie that in with the case that we have before us, the anticipation point is dangerous. The reason it's dangerous, as I say, if I have done nothing wrong, even if I'm told we have concerns about your income, if they are bona fide transactions within my, I don't like using myself as an example, but I've done it, within my bank statements, I'm not alert to the fact that a third party may find those to be suspicious, because I am not the Secretary of State. It is also...
But Mr. Gadgell, it's not just a few transactions in bank statements or a few invoices. It's the overall picture on which the Secretary of State relies, including the timing of the amendment of the tax return. So it's the discrepancy, the large discrepancy between the amount declared on the tax return and the amount claimed in the application for leave to remain under Tier 1, and it's the timing of the amendment. And those circumstances, aren't they suspicious?
My lady, certainly the authorities would point to that, Khan being one of those. The fact that there's been an amendment and the timing is yes, something that Mr. Justice Martin Spencer indicated does, and of course...
So you would accept that the circumstances are suspicious?
My lady, yes, because...
And what's more, the appellant knows that the Secretary of State suspects that he's being dishonest, because the Secretary of State has told him several times.
Balajigari confirms what was said with some amendment, of course, by Mr. Justice Martin Spencer and Khan, namely that discrepant figures may arouse suspicion, and legitimately so. That is, in my submission, not the same as the appellant being aware of the intricate concerns that the Secretary of State has.
Well, we're talking about predictability here. The Secretary of State says, and I'm simplifying here deliberately, this all looks very fishy. You've given different numbers to different government departments, and then you've produced some documents. I want to see some more. At the moment, I think you're lying about that. Now, isn't the incentive to anticipate every reasonable objection to the documents that are produced and try and deal with it? So, to say, for example, look, I've taken a lot of cash, but that's perfectly normal in this business. Nothing suspicious about that. And here is some evidence to support that. It's not just me. And one could multiply examples. I mean, these are obvious things that anyone's going to raise an eyebrow at, unless there's some reason not to.
My lord, I think that I take on board the court's position. I think that has to be seen through the lens of the burden of proof. This is an adversarial element of the process. The burden is on the Secretary of State. And pinned onto that, because that may come across as an unattractive response, is how counterintuitive it is to volunteer information on something that the appellant says is entirely bona fides and legitimate, which a Secretary of State may not have had concerns about in the first instance. And insofar as predictability is concerned, it is, of course, a subjective element. If the appellant's position is, well, this is the norm in my industry, I see nothing wrong with it.
But you keep saying that. Is there any documentary evidence at all that he told the Secretary of State that? And is there any documentary evidence? No. I mean, when he went to the tribunal, because you would have thought, I know that it's post facto and so on, but I would have expected a witness statement to the tribunal saying, I was treated unfairly. This had a real effect on me, because if only I'd known that she was worried about cash, that's what you do in my business. Doesn't matter if I'm serving paralegals or technology companies or husbands and wives who live in the same address that I'm currently living in. Doesn't matter. Quite usual.
The answer to your question is no, my lord.
Put any witness statements in to that effect?
The answer to your question is no, my lord. But
then how can we assume that it is industry practice?
If we step away from the industry practice point, and as I say, the answer it's a straightforward no.
We don't have any evidence at all. All we have is what he was told, I think you're lying, please give me all the evidence. He provides the evidence, and the Secretary of State says the evidence is fishy. So we can't assume that there is a reasonable explanation in terms of industry practice. We can't even know, it's pure speculation, that if he was forced to do a witness statement with a statement of truth on it, which could lead to contempt, that he would say, yes, it's industry practice, or whether he might say, no, I can't sign that statement because it's not true. We just don't know.
Insofar as the cash is concerned, I can take that point no further than what I've said in terms of my oral submissions, but it applies far more neatly to one of the other concerns the Secretary of State has, as indeed does do all of my submissions, which is the variation of the price. You prepare business plans or you prepare documents for your clients, and they are all of varying price.
Well, he was asked to give details of the work done.
Indeed, but that does not, in my submission, cry out in terms of the question of predictability that my Lord Justice Warby has put forward. It doesn't cry out for an explanation.
But it does, because he was asked to provide details of the work he'd done.
My lady, yes, but that does not, in my submission, lead to a conclusion that simply because the prices charged are different, that there must be something untoward within the invoice.
Well, no, because if there were a full explanation of what work had been done, it might be self-evident.
Well, my lady, the appellant's position remains that, with the greatest of respect to the Secretary of State, perhaps required an application of common sense, that different pieces of work, a business plan, my respectful submission, it doesn't call out for an explanation. Different business plans will involve different businesses.
No, if she'd never asked, sorry, but when she says, please provide a breakdown of who your clients were during this claiming period, what their businesses were, and a detailed explanation of what work you conducted for them. And all you get is invoices which show month after month you're giving them services, and the amounts vary, sometimes by as much as £1,100, by a third. Anyway, sorry, I cut off my lady in my excitement.
No, I was about to make the same point.
Oh, right. Great minds think alike and fools seldom differ, yes. Anyway, we've gone through that. You wanted to take us to the other. So you've got 2D2342, where you say, be careful, you can't anticipate what the Secretary of State is going to make of the explanations, and therefore you need to be given notice of the possible explanations.
My Lord, just on the pricing point, he has dealt with this previously, touching upon the varying prices. I won't invite the court to go back to the supplementary bundle, but it was in the first interview that was conducted back in 2017. At question 18,
Yeah.
he was asked, how do you assess the cost for the services you provide? And his response was, this is the final document, entry bundle for my lord, 102. If it comes to like a business plan, if I provide a personal plan that will give them a complete project, it could be from £1,000 to £3,000. So he's already planted the seed for the fact that there is a variation in the prices that have occurred.
Well, I technosolid, they called that were regular site visits and so on. It wasn't the plans.
But again,
When you go back to the invoices.
what that entails, especially when we're looking at, in some cases, fairly historic work that's been done, the appellant would say that on the face of it, in response to the letter, an adequate explanation had been provided. Just sticking with duty for a moment.
The duty is you can't the individual claimant can't be expected to anticipate the views that the Secretary of State will take about things, and should therefore have given him the opportunity to comment on that. Yeah.
My Lord, across the page at 243, it just reiterates that point in Lord Mustill's speech, again between E and G of internal 563, that the right to make representations is of little value unless the maker has knowledge in advance of the considerations which, unless effectively challenged, may lead to an adverse decision. It goes on beyond that to talk about the proposition of common sense will in many instances require an explicit disclosure of the substance of the matters.
I'm so sorry, which page are we on? It's my fault.
This is the bundle page 243, my lady.
Thank you very much.
And it's, again, we're between paragraphs E and G on the side.
Thank you.
This comes in a discussion at D. The central question is whether the prisoner is entitled to and what materials the Secretary of State would found upon when making his decision. And it says approaching the matter in this way must be asked whether the prisoner is entitled to be informed of that part of material before the Secretary of State, which consists of the judge's opinions and their reasons. This is fixing the minimum tariff. Here, of course, the material is actually the invoices, but you say it's also the investigations and the views taken about those invoices.
My Lord, yes, I think it should be read as encompassing those points.
Yep.
The next authority closest to home on the facts is the well-known authority of Balajagari. That's contained in volume 2 of the authorities.
Yeah.
It starts at page 676. And we are, of course, familiar with the facts of Balajagari, so the court will hopefully forgive me if I don't converse over what was discussed by the Court of Appeal. The issue of procedural fairness was dealt with at internal page 695.
Sorry, I've got it loose. Could you just give me the paragraph number, please, Mr.
It's paragraph 50 that I'm beginning with, my lady Balajagari. Paragraph 50 begins by drawing some comparisons with the good character requirement under Section 6 of the British Nationality Act and the recognition that, in effect, everyone knows what the good character requirement requires. We know from certainly the cases that I've cared for before Lord Justice Lewis of the good character guidance that exists in these cases. It isn't the same situation when it comes to a 3225 where there are intricate considerations of the facts. Para 51 just provides us with a reminder of the seriousness of the allegation of dishonesty that is being put forward. Paragraph 55, 696 of the authorities bundle, Lord Justice Underhill sets out the court's conclusion on account of the fact that the Secretary of State is minded to refuse indefinite leave to remain on the basis of paragraph 3225, ultimately that he is required as a matter of procedural fairness to indicate clearly to the applicant that he has that suspicion and to give the applicant the opportunity to respond. Now, that is again a matter for the court to determine in this case whether the minded to refuse correspondence and indeed all of the other material that was before Judge Kabili constituted a clear indication of her concerns. The appellant's position, the court is fully aware of, is that it didn't on
No, not his concerns. That he has a suspicion that the applicant is guilty of dishonesty. That's what he must notify according to paragraph 55.
Well, my lord, yes, but the point I was going to make in respect to paragraph 55 is what then follows, to give the applicant an opportunity to respond.
Yeah.
That must, in my submission, be read as a reasonable opportunity to respond, and it is then for the court today to determine whether a reasonable opportunity was in fact afforded. Now, on the question of anticipation, from Lady Justice Laing, it will be paragraphs 159 to 160 of Balajagari that I'll touch upon briefly. That is contained at pages 719 to 720. Now, this deals with one of the four linked appellants in this case, Mr. Awais Kawas. The difference for Mr. Kawas compared to the remaining appellants was that he was interviewed, and the submission was made on behalf of the Secretary of State, that this satisfied the requirements of procedural fairness on account of him having been given a reasonable opportunity to respond. What paragraph 160 then goes on to do, albeit I accept, as Lord Justice Underhill says, not without hesitation, is that this was not deemed to be enough.
Well, you've got to look above at what happened. Yeah. There was an interview, there's no letter. At first sight, the Secretary of State did exactly what was required of him by putting to Mr. Kawas in an interview the very discrepancy, the difference in the figures on which he based his subsequent decision. We agree that it wasn't essential that he be told he was accused of fraud. It would have been better if it had been put to him explicitly that the Secretary of State was minded to take the view that he had deliberately produced false figures, either to HMRC or to the Home Office, but we accept that what was said was enough. And then and here it's very different, because the letter says, we think you're guilty of dishonesty. And then on balance, however, not without hesitation, we do not agree with the judge's conclusions. We do not believe it fair that he should be expected to give detailed and definitive answers to an accusation of dishonesty without any prior notice. That's, he can't just be asked at the interview, isn't it?
My lord.
Yeah.
And I'm not...
And he must have been expected to know, i.e. prior to the interview, what the Secretary of State had in mind, and he should have come, yes, prepared to face an interview in which he would have given the detailed explanation. So it is different, isn't it, on the facts?
My lord, it is different on the facts, and I'm not seeking to suggest that the level of correspondence or indeed the detail that was contained before, we don't have the full material for Mr. Cowles, but I'm not seeking to suggest that it was identical. But the principle that I'd invite the court to draw from this is the question of anticipation, and this supports my earlier submission. If Mr. Khan was in fact innocent, why should he have anticipated the concerns that follow from...
Because the Secretary of State told him in the letter, we don't think you are innocent, we think you're lying. Give us everything. That's the difference, isn't it, factually? Anyway, we've got your submissions and you know what's troubling us. Yes.
My lord, yes, and the point is, give us everything, as the court has put it, to summarise the mandatory refuse letter, doesn't, in my submission, fit within what is said at paragraph 160. The anticipation point doesn't flow naturally from the fact that he's been invited to provide material and warned of the Secretary of State's suspicions.
Well, wait a minute. I mean, the mandatory refuse letter asked for specific types of information. It didn't, with all due respect to Justice Lewis, it didn't say give us everything. And he did already know that he was expected in response to the second-minded to refuse letter to give what Lord Justice Underhill referred to as a detailed and definitive answer to an accusation of dishonesty. That's precisely the point of the mandatory refuse, the second mandatory refuse letter.
My lady, I take that point. I go back to the point that was made by my Lord Justice Warby in terms of the predictability element of it, which is where we say that the appellant as a subjective position, in a position where he finds himself or considers himself to have been innocent, would not predict that the Secretary of State would have the concerns that she does. What he is also entitled to do, and I say this, I don't like the phrase and I say it with the greatest of respect, is to assume that the decision maker will approach the evidence with a degree of common sense and business knowledge, which in my submission is not in keeping with certain elements of the findings that were made in the refusal letter.
Well, of which we, if that's this industry works on a cash basis, of which we have no knowledge.
I'll shy away from that submission for now, my lord. But the other points I've made, the variation of prices, for example.
The prices, yeah.
And
Can we go back to paragraph 55? Because I think this case is about something slightly different, possibly, on analysis than Balajigar. If we go back to 55 and read the whole of it, where the Secretary is minded to refuse leave on the basis of the applicant's dishonesty or other reprehensible conduct, he is required as a matter of procedural fairness to indicate clearly to the applicant that he has that suspicion. That's what he has to tell the applicant. I think that you are or might be dishonest. Then you must give them an opportunity to respond, and then at the end to take the response into account before drawing the conclusion that there has been such conduct. So this paragraph is thinking simply, tell him that you're dishonest, there's a discrepancy in the figures, and we don't think it's innocent, we think you're manipulating the figures, you're dishonest. Give him the chance to respond, listen to what he's said, and take that into account. So if you put that template over the facts here, he was told, we think you're dishonest, we think these figures don't stack up.
I don't deny that.
And then he was given the opportunity to respond, and he was actually asked to provide certain specific information. My over-elaboration was too broad. And then the Secretary of State has taken that into account. And I wonder if we're not at the third stage, when taking that into account, if she's going to formulate views about what he said, which are adverse to him, does she have to go back and say, well, I know I've got your account now, and I know I've got your explanation, but I think there are problems with that explanation for these reasons. What do you have to say about those reasons? That seems to me to be where we are at the stage in Khan. It's the stage further on from Balajigari.
My lord, absolutely, and this is, my lord will recall my earlier point about paragraph 55 being reasonably read as including that the Secretary of State affords the applicant a reasonable opportunity.
Yeah, but I don't think it is the opportunity, because he's had the opportunity and he's said everything and given everything he wants to, knowing full well that is an allegation of fraud. And I wonder if you're trying to, if the issue is to build a further stage into the third stage, if you're going to take them into account, but you're taking them into account and drawing adverse conclusions from what he said, you have to go back and put that to him. I suppose you could say that then puts it back to the second stage. But what triggers the need for further exchange is not the failure to notify of the dishonesty, but it's the drawing of adverse inferences from the explanation and documents that he's provided.
Absolutely, my lord. And certainly one of the authorities that deals with the child assessment point saw the court grapple with this in a different factual matrix. And I'm not uncomfortable with either of the two positions that my lord has taken being put forward, whether it's an extension of the Balajigari principle to include a third element, or alternatively it being read into the
part of the second
that's already there. But ultimately, the preference is for it to be treated as part of paragraph 55 as it stands, because the opportunity to respond is not a singular event. If it was, the Secretary of State would have issued the single-minded to refuse letter, which did put it in terms that there were concerns, and invited him to respond and left it at that. But she's, if we look at her conduct in this litigation, she's withdrawn a number of refusal letters, gone back and invited further information. So it really is about the reasonableness of that opportunity, and that doesn't have to be in a single letter with one shot on target. Understandably, whether we look at the predictability on the facts of this case or not, there will be cases where the information that is provided gives rise to additional questions. It would be wrong, in my submission, and by that procedurally unfair, for the Secretary of State to say, well, you've had one shot, I'm not going to go back, whether it's for cost reasons or otherwise, and afford you another opportunity. And that is live in this case as well as in hypothetical scenarios where there has been further research that's been conducted, some of which I think both the Secretary of State in pleadings and Upper Tribunal Judge Kabidi, in fact, reached the conclusion were of lower merit, if any merit at all. But ultimately, in my submission, this should form part of the second sentence in Balajagari.
Are there any authorities that you're aware of in the ones that we've got that deal with it in the alternative way that we've canvassed? That if, in the course of considering the responses and the evidence provided, a decision maker draws adverse inferences when procedural fairness might arise. I can see possibly, say for example, you were looking through the documents and you came across evidence that, goodness me, he's not just forged this, he's whole-scale forgery, he's selling passports and engaged in blackmail, not this case, and so on. And I can see there you'd have to say, well, hang on a moment, that's a different allegation of dishonesty, but dealing with the explanation for the dishonesty that you're accused of. Do you know any authorities in the ones we've got which deal with it in terms of if you are accused of one thing, you make an explanation or provide evidence before the Secretary of State can reach a final decision, there's a need to go back, if you like, for a second time? Or it's just something that hasn't been decided yet?
I think not on fact, but on principle, the case of FZ, which is in volume 2.
Yeah.
This is FZ and the London Borough of Croydon Court of Appeal decision from 2011 is potentially on point, and the arguments were made, as he then was by Janet. In essence, this was a case that involved, just lost my
You've got a page number for it.
789.
No.
Unaccompanied asylum seeker, age assessment case, claiming to be 17 years old at the date of entry. There were concerns that were raised about the procedural fairness in this particular litigation, and I think the relevant paragraphs in terms of the judgment itself and the arguments that were made start from paragraph 19 at 796. The argument that was made by Mr. Luber at the time was that, as of course is enshrined in Balajagari to a certain extent and duty, that where matters are likely to adversely weigh against him, he should be given the opportunity to respond.
I wonder if there's a different analogy, and I know that it's controversial to compare this process with cross-examination, but just take this question. If in the course of a criminal proceeding it's put to the defendant, you have dishonestly inflated or reduced your income, haven't you? And the witness then calls evidence, including a lot of documents, and is not questioned upon them by counsel, and no speech is made about the detail of any of those documents. It's still open to a jury, isn't it, to conclude that they just don't accept any of the evidence that's been called as credible. So that's, I'm just wondering whether the counsel doesn't say, well, members of the jury, I invite you to disbelieve what the witness has said. It's all incredible. The details, all these reasons are there for you to consider as to why these documents are not credible. That would be an unfair procedure, not having put that to the witness. But the jury is still entitled to, as Mr. Justice Eady once said, decide that they don't like the cut of the witness's jib. Just disbelieve what he's said.
My lord, straying away from the criminal jurisdiction in which I lack the experience to respond, This case has involved, in the particular facts before you, some comparisons or use of the word cross-examination. If the appellant had been denied any form of leave to remain in the United Kingdom, and as opposed to being granted 30 months, he would have had a refusal of a human rights claim, which would have attracted a right of appeal.
Well, that's not relevant, is it?
No.
All I'm trying to do here is to distinguish, put up a different analogy from the one that my Lord has put to you, in which no one's drawing adverse inferences from the evidence given in response to the charge. You have inflated your figures. No one's drawing adverse inference. They're just saying, well, you've given your answer. We just don't believe it. We've told you what our case is. We just don't believe your answer to it.
My Lord, I think in straying as far away from that as I possibly can, if this were, and the reason I've made the Article 8 point is because that would attract a right of appeal with the matter coming before an independent immigration judge. If we play that out as a tribunal hearing in the first tier, if, for reasons of competence or otherwise, or administrative resources, the presenting officer or the representative for the Secretary of State does not put significant elements of the case arising out of evidence that's been submitted as part of the appeal bundle to the witness, and it's not contained within the refusal letter for sufficient notice to be given, but that ultimately becomes the crux of the findings made by a first-tier judge against the appellant, there would be a strong case in those circumstances to initiate an appeal for permission to the upper tribunal by arguing that matters weren't put, evidence.
But what would be the argument? That is it a reasons or irrational conclusion because the judge has based the decision on matters which were not in dispute between the parties and where the parties took a different view or which wasn't challenged? Because one way of analysing it, going down my Lord's way, is to say the Secretary of State says, I've read everything you've said, I don't believe a word of it, full stop. You may then challenge on the grounds that that's not rational, or that she hasn't given reasons. But then if she does give reasons and says, well, I don't believe you because this is all cash and you've not suggested anything to explain why it's cash, you would then say, that's not no rationality or reasons challenge. If that was the reason she was going to give for disbelieving you, she must go back and say, the reason why I think you're lying has got worse. It's not just the discrepancy now, it's the cash. And that's
the point. It's the category of challenge that you'd be making. Would it be an unfair trial process challenge, or would it be an irrationality challenge? That decision is simply not open to a jury on the evidence that was called before them, or was it an unfair trial because they were left to make a decision that was not explained to them?
Primarily, I think we'd be looking at a fairness point, but certainly there could be a degree of overlap insofar as the consideration, dependent on the facts and, of course, precisely what is said and how a trial transpires. There could be arguments of irrationality, but for the purposes of the submissions before the court today, it is a concern on procedural fairness grounds. The reason I've taken the court, if I may, to FSED is that paragraphs 21 and 22, I think this is Sir Anthony May dealing with the matter, touch upon the process that was used by interviewing officers on behalf of the local authority. And the suggestion was made that where an interview is conducted and material evidence answers are put forward, which give rise to additional questions, the appropriate course of action would be for the interviewers to retire to go and discuss any concerns they have, to come back, and then to ultimately put those concerns before perhaps again retiring to reach their decision. Insofar as the court's reasoning at paragraph 22 is concerned, it appears to adopt that point as being procedurally correct on the facts that were set out and in line with the Merton authority. Although, and just reading the middle of the paragraph, although the interviewing social workers withdrew to consider their decision, when they returned they presented him with their conclusions without first giving him the opportunity to respond or to deal with the adverse points. That is, as we say, on all fours with what has happened.
That's right. I want you just to understand on the facts. This was, again, one process, one time scale. They had an interview when they were asking him questions. and then they reached the conclusion that there wasn't a gap between receipt of information and saying, I don't believe that, and the person concerned having the opportunity to come back before a final decision was taken.
My lord, yes.
So this is slightly different.
My lord, I would say that this is arguably, setting aside the factual differences, mechanically on all fours. The interview takes place, as paragraph 22 indicates. Social workers withdrew, return and present their adverse conclusions. That is, albeit that the material here was largely done on the papers, no different to the circumstances arising here.
But it is different, Mr. Gajal, surely, because in this case you've got a long history of the Secretary of State making decisions, withdrawing them, sending minded to refuse letters. So there could be no possible doubt in the appellant's mind about what the underlying allegation was.
My lady, the long history is accepted, and one of the reasons I took so much of the court's time this morning to go through the history of the correspondence is to indicate that if we pile all of that correspondence and we jot down the various allegations that were put, the concerns that become findings, the suspicions that become findings vis-à-vis the material that was finally submitted, was not.
Well, the concern and the finding was that he's dishonest, full stop. He lied about his income, he inflated it. The reasons why started off being the discrepancy, the fact he didn't check, this mystical spreadsheet error and so on. I'm deliberately being provocative now, before my lady gets concerned. It's all of those things. And then she says, come on, send me specific categories of information, you persuade me. And he sends it and she says, sorry mate, don't believe that either. Cash? No way. 2 people at the same address? Ha ha. That's what she says basically. And you say, well, hold on a moment. If she's going to say that, if there are going to be more critical findings, then in fairness, you say she's got to go back and say, look, you made it worse for yourself. Do you really expect me to believe this? You're not just discrepancy. You're falsifying the invoices now. Or whatever she thinks. Yes.
Oh.
And that's what you say, really, is it's moved on from basic discrepancy to further allegations of widespread dishonesty, which were never put to him, in which you say he might have had a simple explanation for, in effect.
My lord, yes. And if we look at paragraph 22 and criticism levied at the interviewing social workers being that when they returned, they presented their conclusions without first giving him the opportunity to deal with those points. And so looking at the history of that case, the concerns that factually trouble the social workers, I think centred around a vaccination card that...
Well, it was the Iranian calendar, the birth date, to be fair to him, looking at it, because we weren't thinking about a different calendar. They didn't believe his birth date, and there was an explanation. And also there was a vaccination card which showed what date he would have been at the time that he got vaccinated for that. It was a couple of things, yes. Reading it quickly.
My lord, yes. And that's one of the authorities. Now, if I may then move on to... I'm taking them out of order to deal with my Lord Justice Warby's position in terms of the procedural fairness point.
I'm just making a note of what you say in this case. And my note says that the additional material relied on becomes the decisive factor. Is that a fair summary of what you're saying?
It forms a significant chunk of the decisive factor. And the point I think that was made by my Lady Justice Laing was that we have the concerns that are centred around his involvement with HMRC and the discrepant declaration that was made, and there has been toing and froing, and from an early stage he's been aware of that concern. What the Secretary of State has felt the need to do, and I would invite the court to infer from it, is she's withdrawn decisions, remade them with additional material, suggesting that there's a need to prop up the original allegation. Now,
that's a very difficult... That really is a completely different grounds of appeal, and that's the first instant thing. You are now saying, you're lying, and that's not what we're dealing with.
No,
you can't make that submission.
I've misexplained myself. one of the authorities that the Secretary of State relies on is the Court of Appeal's decision in Hussein, which makes the uncontroversial point of saying that one essentially has to look at all of the evidence in the round holistically.
Yeah.
That is well accepted within the field of immigration
Yeah.
law. The point we make is that, yes, he may have been aware of the allegations. He was aware, but is unequivocally of the allegations vis-à-vis HMRC. But when it comes to his invoices and the concerns that were raised with the income that was coming in and whether that had been falsified, there was an inadequate opportunity and inadequate notice. The materiality point, and this comes to section 16 and whether the outcome would have been substantially different, is given where the Secretary of State ends up, the structure and the nature of the final refusal letter, we cannot be satisfied that if we take away the concerns in respect of the income and what is said there,
That you'd have reached the same conclusion on the discrepancy alone.
indeed, given the need to take everything into account, the more discrepancies there are, the more red flags, the more unexplained instances that the Secretary of State can identify, the stronger her case becomes that there is something in the appellant's character and conduct which warrants the paragraph 3225 biting.
Again, putting it a different way, the last time I'll intervene and let you get on, is, in effect, dishonesty covers two broad things now. The discrepancy, he told one thing to the Inland Revenue, he told something different to the Home Office. And there's a second strand of dishonesty now, he's falsifying invoices. And she never went back and said, you're falsifying invoices. It's as if she found he was forging documents and selling them. It's a new species of dishonesty. And if she's going to say, hang on, you're not just undeclaring your income, you're forging it. She should have gone back and said, in fairness, you say to him, look, the dishonesty allegations have become something a bit more serious now. And then the question maybe for us is, were these allegations essentially one allegation, dishonesty about income and inflation of income, or had the investigation spawned a separate subspecies of dishonesty, if you like? Fraudulent invoicing, recorded that as opposed to HMRC discrepancy. You can see what I'm driving at. My lady would like it because it's not tight enough, but you can see broadly what I'm getting at.
My lord, yes.
And that's what you say, I think, that this is a new species of specific dishonesty allegations that, based on her investigations, which should in fairness have been put to him.
My lord, yes, and it's not just, I'll move from the point very quickly, but it's not just, of course, the falsifying of invoices. She also talks in the refusal letter about the recirculation of money, suggesting that this is recycled income for money that simply doesn't in reality exist beyond perhaps a small sum. The next authority taking them out of turn that I wanted to draw the court's attention to is in tab 2 of the authorities bundle. It's the decision of Tribunal Judge Canavan in Williams. This is starting at 1056. Again, this wasn't on all fours. It's a 3225 case that involves declarations, or in this case, the absence of declarations to HMRC. Mr. Williams, for the years spanning between 2010 and 2014, appears to have made no declarations of income to HMRC, which is the Secretary of State. He does what is expected. He makes his application for indefinite leave to remain. 1058, Judge Canavan sets out some of the questions that were asked to him. And the difficulty that Judge Canavan had with this case is that there was a factual error in the Secretary of State's process and her ultimate decision. The Secretary of State approaches this, perhaps with somewhat flimsy language, by treating it as a discrepant declaration to HMRC, whereas in truth there was no discrepancy, he simply made no...
He didn't declare.
Indeed. And insofar as the Secretary of State seeks to suggest that, well, this case is different because this is a discrepancy case as opposed to a non-declaration, that does not detract from the general guidance that was offered by Judge Canavan. In particular, she deals at paragraph 31, this is in the authorities bundle at page 1066, by saying as follows in the third sentence: while I accept that the interview forms one part of the decision-making process, there seems to be little point in interviewing the applicant about the credibility of an application if the central concerns are not tested and put to the applicant to answer. And she goes on to then add as follows: if the only purpose of the interview of the kind that took place in this case is to put template questions to the applicant without testing their evidence or raising potential concerns, it is hardly going to assist the decision maker in assessing their credibility, and ultimately may lead to allegations of unfairness. It's the word tested and testing that's been used that we say is absent from Mr. Khan's case. This isn't a case where the appellant is saying an interview is required. Of course, Balajagari accepts that the paper process may, in a number of these instances, be sufficient. But if we aren't going to have an interview, if, because of the statutory regime, there is going to be no independent appeal which gives rise to cross-examination in front of an independent decision-maker, then the paper process needs to be sufficiently detailed to test the evidence. Now, if that involves an expansion of paragraph 55 of Balajagari, if it can't be read in the way that I suggest, to include a toing and froing, if additional concerns arise, then in my submission, so be it, because that is what fairness requires in line with paragraph 31 of what should be an uncontroversial position taken by Judge Canavan. It hasn't been tested, and it cannot, as I've indicated, be safely assumed that the appellant will be on notice. Conscious that we're only on my first submission and my time marker is fast approaching, I may deal with the remainder of the authorities at some speed, if I may, unless that troubles the court. The court will be familiar with decisions of Mr. Justice McCloskey, in particular in Volume 2 in the case of Anjum. And this can be found starting at page 1068. Again, not on all fours. Anjum was a Tier 1 entrepreneur application where there were concerns about the manner in which the interview was conducted. 1068 has the judicial headnote where the question of fairness is dealt with by Mr. Justice McCloskey, indicating that an interview may be unfair, rendering the resulting decision unlawful where there's been an inflexible structural adherence to prepared questions, excluding spontaneity, or, and just skipping through that headnote, a failure to probe and elucidate on the answers that are given. Again, I accept that the content of the interview and what Mr. Justice McCloskey was dealing with are not on all fours with the material that you have before you. There was a factual error that was made by both the entry clearance officer and on review the entry clearance manager. But the proposition and the judicial headnote can be carried over.
You've got to test it, and if you use a paper process, you can't just test it once. That's not testing.
And that is, in my submission, echoed in the title that's been given to the authority. It isn't limited to factual errors. Mr. Justice McCloskey and the Upper Tribunal have treated this as entrepreneur business expansion, fairness generally. So that deals with Anjum. We then have the case of AF. This was a decision of the House of Lords going back to Volume 1 of the House of Authorities. Tab 5, if the court is blessed with tab, then not. It's
249.
Thank you, my lord. Now, again, not on all fours. This dealt with the disclosure of closed material in cases involving suspected terrorism and control orders. In essence, what I'd invite the court to take away from this is the qualification. This is the point I make about Judge Kabedi's decision. There are references, understandably so, following on from Lord Mustill's position to the requirement to give the gist of the material that is being, or the gist of the concern. That is not a scientific term, it is not a mathematical term, and in line with the remainder of the guidance in duty, is likely to vary dependent on the factual circumstances of the case.
if the allegations vary or become enlarged, the gist varies and becomes enlarged.
Indeed, my lord. The particular paragraphs of note are 54, 59 and 60, which can be found, so that's 54, 59 and 60, pages 281 onwards, it's going on to 293. The importance of 54 is it deals with the ability of an appellant to effectively give instructions, in this case to the special advocate, to mount an effective challenge to the allegations that were to follow. The appellant, this goes back again to my Lord Justice Warby's position in respect of predictability, would maintain that what was before the appellant in the various correspondence that had been put forward did not warn him to a sufficient degree to allow him to give instructions of what he would have said had the Secretary of State given him the opportunity. The question...
But these were all his materials. This is not a case where there's a mass of closed material which the Secretary of State is keeping close to her chest and not telling him about. The Secretary of State has said, I think you've been dishonest, and has then asked for a range of different types of information to give him an opportunity to show that he hadn't been dishonest. So it's a million miles away from this case, isn't it?
My lady, I accept they are all his materials, but we then go back to the first authority of duty that I referred to, where Lord Justice Lord Mustill, forgive me, makes reference to the fact that prisoners will be aware of the material that's been used against them. So they're fully aware.
No, but they're not aware. In duty, they weren't aware of what the judges have to say about their case.
What the key takeaway is from the paragraphs that I referred the court to in duty is that whilst the appellant is aware of the material, he is not aware of the impression that that material has had on the Secretary of State.
Okay.
And that's the point that's essentially made. Now, 59 and 60 start to remind us that there are limits to procedural fairness.
So 59 is the paragraph beginning contrary to Mr. Eady's submission. Because there's...
This is
don't forget...
283, my lord.
Well, that's the Court of Appeal decision in this case, isn't it? It went to the House of Lords.
Yes, that's right, my lord.
So shouldn't we be looking at the House of Lords rather than the Court of Appeal, unless the House of Lords didn't deal with this point?
I'm not entirely sure what's happened there, my lord.
Well, what's happened is in the official law reports, when you have the House of Lords case, you often have the Court of Appeal decision first and the House of Lords after. And I was looking at the House of Lords paragraph 54, 59 and 60, and that made me think, oh, hold on a moment, I think you're dealing with the Court of Appeal 54, 59 and 60. And if so, I'm not sure how much that helps us.
Well, in reality, neither paragraph is needed simply to make the very brief point, which is that there are qualifications of procedural unfairness, again, in context of closed material where national security concerns may stop material from being disclosed. We don't have any of those barriers that would stop the Secretary of State in this instance going back and engaging as the case of FZ would suggest is required.
Well, I think according to the head note, the House of Lords concluded that a decision based solely or to a decisive extent on undisclosed materials would not satisfy Article 6. Well, that goes back to my earlier point.
Indeed.
You're not saying that the reasons that you complain were undisclosed were decisive. You said, I think, and I've written down, a significant chunk of a decisive factor.
My lord, yes, because we have the two. If we simplify the refusal letter into two strands, we've got the concerns with HMRC, which is one element, and then the concerns with the appellant's income as
the discrepancy and the preparation of inflated invoices.
Indeed.
Yeah.
And
you say we can't tell, but this is your fourth ground, I think.
Yes.
Material.
Yes, and
we can't tell.
And the reasons I say I haven't dealt with that separately in my skeleton.
Well, for the Secretary of State to prove that the decision is highly likely that the outcome for the applicant would not have been substantially different. Yeah. Right, so that's AF. Then anything else? Any authorities on ground one?
I think two or three additional authorities. The case of Taj is one that the Secretary of State relies on. This is tab 15.
Neither Lord Justice Lewis nor I have some tabs.
It's
in our
651.
authorities bundle.
Having
So-
complained bitterly about the absence of page numbers, I thought I wouldn't complain about tabs as well, because I've got the index and it's 651. You've got tabs as well, have you? Just
I've got tabs, yes.
oh, tabs and page numbers, actually.
They're not numbered, but
Oh, right.
they are tabs.
Yeah, 651.
My Lord, yes, that's the starting point in respect to the Court of Appeal's decision. It bears emphasis in this case that the Court of Appeal's conclusion on procedural unfairness, we're dealing with an entirely separate factual nature.
It's the points-based system, and it's whether he provided the information, did they have to go back? And somewhere in the judgment, Lord Justice Green does say this is not a dishonesty case, I think, but I can't remember which paragraph he says that now.
It is paragraph 65, page 669, where the point is made that in any event the present case at its core is not at its core about veracity of the applicant, but is about the paucity and inadequacy of the evidence.
It's the points-based system, and he's got to provide the information, and if he doesn't, you don't have to go back and say you haven't provided the information, it's his fault. But you say that's different from this, because this is an allegation of dishonesty.
Absolutely, my Lord, and the burden shifts to the or the burden starts with the Secretary of State in those circumstances. We're looking at a different factual matrix, different legal test. And in terms of takeaways, there's a great deal of material insofar as Taj is concerned, not only dealing with the paucity element in the absence of the allegation of dishonesty, but also going back to page 665, the sideline of material. This is paragraph 50, sub 3, so it's the bottom third of the page, just under the second hole punch. And just effectively emphasising the importance of procedural fairness and the general position that the court don't undertake a detailed analysis of, in effect, what would have been said.
Yeah. Right. Anything else from Taj?
I beg your pardon?
Anything else from Taj?
Yes, I think just paragraph 54 as well. This is at page 667. This is just above the letter E on the right-hand column. Questions of fairness will often focus and depend upon who has access to the information needed to support the application and who has control over that information. Well, here the question here is who has the concerns.
Yes, it's different. I mean, he has control, but you're not saying you haven't provided enough information. What you're saying is it's the inferences you draw from them.
My Lord, yes, and the distinctions can also be drawn in paragraph 55 vis-a-vis the open and transparent nature of the points-based system, the claimant really tying in with what's said at paragraph 65 about being well aware of what's needed and the paucity of documents that follow in comparison to what we say are unpredictable allegations that the Secretary of State has made and that he wasn't given the opportunity to respond to. So that I think in terms of Taj deals with the point. My learned friend also, during the course of her skeleton argument, relies on the case of Lloyd and McMahon. That's at tab 8 of the bundle of authorities, which page-wise is at 427 onwards.
Yeah.
There are a number of reasons why the appellant says this authority doesn't advance or support the Secretary of State's case. Insofar as background is concerned, there were the district auditor in this instance had concerns that local councillors were not setting rates and that in doing so they had engaged in willful misconduct. They were given the opportunity to respond in writing. It was a group of councillors who were given the opportunity to respond in writing. There was, within the facts of the case, written representations that were put forward. No request had been made for an oral hearing and one was not ultimately given. And complaints were subsequently raised when the district councillor reached the conclusion that they had been engaged in willful misconduct, that this was procedurally unfair in the absence of, in addition to other factors, a hearing. The point And ultimately, the court's conclusions included that. Just trying to pull up the page number, if I may. It's the judgment of Lord Keith, starting at 498, insofar as my submissions are concerned, which explained why, in this case, there was no procedural unfairness. It begins, so this is 498 of the authorities bundle, less C on the right column, by accepting that the district auditor had given the opportunity to the councillors to put forward representations, and there can be no claim that this was contrary to the rules of justice. It goes on to, in some respects, and I'll try and be as careful as I can in my submission, to criticise the councillors for not requesting an oral hearing and indicating that there was no reason to suppose that if an oral hearing had been requested, one would not be granted. This is at D. Then E describes how, when the notice was provided to the councillors in question, they were given copies of the documents that the district auditor was seeking to rely upon. They included internal minutes and other materials, which ultimately concluded pointed towards there having been willful misconduct. That we can see at F. Crucially, at G, Lord Keith noted that no facts contrary or supplementary to the contents of the documents were or are relied upon by either side. It goes on to sort of look into the future and see what may have happened if an oral hearing had been put forward, but says that the councillors would have done no more than simply have reiterated their sincerity. There is an important point at 499, where it's ultimately at the top of 499 between A and C. Lord Keith considered the point made by counsel for the appellants that additional reasons had been put forward by the auditor in the final statement of reasons that were not part of the notice. So this is the point that I make about new material and new reasons that hadn't been put to Mr. Khan in the minded to refuse correspondence or otherwise. What's crucial is two things. First of all, Lord Keith disagrees and says that everything that was required had in fact been put forward. And secondly, there is nothing within Lord Keith's judgment which resonates to say, even if new material had been put forward.
But it doesn't do for this.
No.
So it doesn't help us one way or the other, does it?
No, but insofar as the Secretary of State makes the point, in my submission, this authority doesn't assist the Secretary of State with showing that there was no procedural unfairness.
Right, okay.
What's also crucial, insofar as the facts of Lloyd are concerned, and this is going on to E, is there is a distinction in the litigation process or litigation mechanism. In Lloyd, there was the opportunity to appeal to the High Court, and the court makes it clear that that was not limited to a judicial review process, but ultimately allowed the High Court to reach the Divisional Court to reach a decision contrary to that made by the auditor. So there's a final process that follows on from the district auditor's statement of reasons. We don't have that here. So in my submission,
you will find it very difficult to establish that the absence of any other procedure by way of appeal and so on leads to unfairness. Had there been such a thing, then it may have been relevant, but it's not going to help you, I'm afraid. Otherwise, every decision that an administrator takes, there's a risk that unless there's a full appeal mechanism before a tribunal or court, is going to be unfair, and that cannot be the law.
And I don't seek to advance that point, my lord, but
yeah. If it is there, it might help, yeah. Anyway, so that's Floyd and McMahon, yeah.
Now, the only other authority which I'm going to mention as opposed to really pushing the court to in any detail is the decision of Rashid and Oil Companies, Mr. Justice Martin Spencer. It's at tab 22, so starts.
Page 826. Yep.
Again, not on all fours, but Captain Rashid was accused of having falsified logs for the time that was spent inspecting ships, and at paragraphs 77 in particular at the bottom, and focusing on 857 of the authorities bundle. Mr. Justice Martin Spencer said as follows: "What would not be fair, having lured the inspector into a false sense of security by assuring him that the topics of interest to the panel would be confined to certain matters, he was then ambushed by questions going beyond the scope of inquiry, and in relation to which he had no fair opportunity to prepare himself and, if necessary, present evidence in advance of the hearing." Again, I'm conscious that there are factual distinctions, that the correspondence involved in this case did indicate that there would be limits to the remit of an inquiry which were breached when the inquiry ultimately took place. But it can be read into Calm and the facts that you have before you that the minded to refuse correspondence and otherwise did not put him on notice of the concerns that were raised. So, slightly concerning in terms of time, but
Don't worry, we've asked you lots of questions, but that's ground one done, really, I think.
that is round one done, Mike.
So ground two?
Ground two is a question of irrationality, and it is dealt with
In the skeleton, yeah.
in the skeleton arguments. I'm not, and to a great deal in my submissions, we've touched upon some of the concerns that the appellant has. Judge Kebedi's decision deals with this in paragraph 34 onward.
Yeah.
In essence, and the criticism is, the observation is made by the Secretary of State that the appellant in his skeleton argument, it doesn't really attack Judge Kebedi's decision, but simply seeks to relitigate the point that was made. The reason that occurs in the fashion it does, my lord, is because paragraph 34 of the Upper Tribunal's judgment does very little then to, it's not paragraph 34.
Yes, 42 is where she starts dealing with the second ground. Nothing irrational arising from a holistic, very fashionable assessment of those factors.
My lord, yes, and in truth, Judge Kebedi, despite the detail that we see in paragraph 42, simply sides with the Secretary of State on the point, and it's the Secretary of State's reasons that were in challenge before her. The concerns that you had are set out at paragraph 20 of my skeleton argument.
Yeah.
I'll focus on a few of the headline points, but do no more than that. We've touched upon the concerns with regards to the pricing issue and what the appellant says was an irrational conclusion. A sensible decision maker rationally dealing with this for the Secretary of State would have appreciated that different work in different contexts will attract a different price. The variation of price points itself, my lord, is dealt with in paragraph 20.
I mean, 20.1, I don't understand the relevance of it. Was it the basis of her decision that he should have known that the rules had changed?
No, my lord. I think
the fact is that if you give evidence to one government department, wouldn't any human being, myself included, assume there's a risk it might go to another one? I mean, what's the point that you're saying is irrational in 20.1?
20.1, essentially the Secretary of State's point isn't that he should have had a better understanding of the rules. It's that, as I understand the Secretary of State's position, the reason he's changed and amended his tax return with HMRC is because he's gotten wind through the grapevine that there had been changes to the immigration rules in 2013, which meant that there would be data sharing and comparisons between the two government departments. The appellant says that that is a jump and it is an impermissible...
But is it relevant to the decision? I know she says it to page 265, but there's still the reason. Why did he suddenly change it then, 3 months?
It goes to motive, my lord, I suppose. If the Secretary of State point is that you were compelled and pushed to amend your tax return on account of the fact that you became aware of the data sharing concerns, then that is not a legitimate reason to change his return. His explanation, as my lord will recall from the documents, is Marks and Marks solicitors, I met with them, they advised me to check my situation situation with HMRC, and it's that investigation that ultimately led to me.
Yeah, and she either believes that or she doesn't.
Indeed, and she takes Judge Cabedi takes a restrictive view of the material that had been provided. 20.2.
Well, it's correct. He didn't declare his income, and it was dishonest in that regard, wasn't it? I thought we established that earlier on this morning. It's not of little relevance. You're supposed to, your obligation as a taxpayer is to declare your income, and he didn't.
Well, my lord, I accept the first element of your question, which is that he didn't declare his income.
Yeah.
But insofar as the second element is that he was dishonest, he does not in any way accept that to be the case. And
Well, I've looked at the documents. It says the tax ones that he's put in says income from self-employment X, total income it's the same, and that's just not true.
Those are the assessments of. I'm not sure we've got the tax returns
Tax
at all.
return.
We've got the assessments.
I don't think.
In other words, the documents generated by HMRC.
So we haven't got his documents.
We haven't got his documents. I haven't actually looked at my own, and I know what they say, but that's not something I can.
Oh, yeah, I was looking at.
But I think we all know.
Yeah, well, I'm
that
looking.
there's a bit on the form where you're asked to declare what your income is from employment,
Absolutely, my lord, and that's not in dispute. And I think.
or you're asked actually to say whether you were employed, and you either say yes or you say no. We don't know what his answer was.
No, because I'm looking at the Inland Revenue things, and that says profit from self-employment, and then total income. But yes, I suppose we don't know, but he didn't declare it.
No, the fact that
And he was required to declare it.
he didn't declare it, he was required to declare it, but in my submission that does not, of itself, warrant.
But also, I mean, I just don't understand. Perhaps you could help me, Mr. Gadjar. The last full sentence on paragraph 20.2 on that page. Thirdly, the fact that the appellant had over £3,600 from PAY income shows that he did not fabricate his self-employed income. How does it show anything?
Well,
in
yes, I
relation
think
to the
that
self-employed income. It's a non sequitur, isn't it?
The thinking behind that submission is as follows, my lady. The Secretary of State's view is that this individual has falsified his income in order to reach the threshold required to obtain the points within the immigration rules and be granted leave to remain. The appellant's position is, why would I falsify my self-employed income if I had at least a chunk of PAY?
Because he's stuck now, he hasn't told the Inland Revenue, and he should have. And he wouldn't be enough to get him home anyway, because he needs more. So he's put it all into the one, thinking out loud what the Secretary of State would be thinking in her office. He's put it all into inflating the income rather than going back over the second error. It just doesn't show anything. We just don't know, do we? All we know is he didn't tell us. He's never put it in the tax return, and there's no evidence from him as to why he did that.
My lord, yes, in terms of evidence there isn't, and we fall back to submission one, but in terms of the observations the court makes, it wasn't a case that he was stuck with it, and the chronology would go against that initial observation. The application for leave as a Tier 1 migrant was made on the 4th of April 2013. By that point, he hasn't made a tax declaration to HMRC, which doesn't follow for that particular year until at some point in Jan 2014. So he's not stuck with...
Well, if he gets stuck, the fact of the matter is, he should have told them this.
Yes.
He didn't tell them this, and he's never explained it.
No.
And that's the end of it, isn't it?
Well, save for submission one of...
But I don't follow how it can, that non-disclosure can be said to show that the appellant didn't fabricate his self-employed income. I just don't see the link.
I think the word show perhaps ought to be replaced with support.
Yeah, he might really have had to forge £27,000 rather than £30,000.
Yes.
I see. Okay.
That's what I think you're trying to get at, isn't it?
But yes, my lord, and ultimately, my lady, insofar as the question is concerned, there is a clear defined boundary as to what the income requirements are to secure points. In my submission, even one who is dishonest would make use of honest income.
Well, that's very interesting, very speculative. if that's what he wanted to explain to the Secretary of State, if he wanted to say, I know I'm not complying with the law, I know I'm not telling you what my taxes are, but there's a reason for that. Or there's a reason for it, I've learnt my lesson and it didn't actually matter in this case, that's fine. But we're not the first instance tribunal, we're not the decision maker, it's on appeal, he didn't do it, he should have done it, and that's the factor. So I don't see why it's irrational to say that, well, he hasn't complied with his tax returns and she must make that what she wants. That's the end of it, and we must decide that.
My Lord has my point.
Yeah. And 20.3, is it irrational? I mean,
what's perplexing about it? I mean, the obvious conclusion, and Judge Kabedi was on to this point, is that you'd use two accountants if you wanted to tell one story to the first set of accountants and a second story to the second set of accountants. Why is it perplexing?
Well, with respect, my lady, the appellant's case would be that it
No, we know what his case is. But
the question is whether it's irrational. You're not persuading us. We're not the decision maker. You're trying to say that the Secretary of State was irrational. Gosh, she should have said to herself, well, this is silly. How can this be right? But as my lady says, there's one potentially obvious explanation. Second is, why should he pay twice for the same thing? And you say, oh, well, he needed a chartered one for the first one. Well, unless the chartered one is very much more expensive, why not use him for both?
I
mean,
think
the rationality is a different thing. It's not for us to debate it. It's for us to decide whether it's irrational. No sensible person could possibly believe that the using of two accountants for returns, one to the Home Office and one to the Inland Revenue, which have marked discrepancies between them, was not irrational.
Well, my Lord, again, shyly using the word industry standard, it isn't necessarily uncommon for two firms of accounts to be used. There is...
Well, that's your evidence, and that's what you say, but we're not arguing about that. We're arguing whether it's irrational for a Secretary of State who says this man has got a big discrepancy between the two forms, and he's used two different accountants. I don't think that's a sensible thing for him to have done. As my lady says, he said might be telling one thing to one to another, and I don't accept his explanation. The question is that irrational?
Well,
not whether we agree with it.
Paragraph 20 of the Scalise argument is intended to put forward a number of factors which the appellant says, when taken together, establish...
All right. Well, if they're all not irrational, taking 20 non-irrational things and adding them up doesn't make one irrational thing. But anyway, let's not take too much time. Why is 24 irrational? She's taken her view about the wording of the letter, and that's it. She doesn't think it's right.
The Secretary of State ultimately accepted that she may be subject to criticism on this point in the detailed grounds that were pleaded.
Well, never mind what the Secretary of State said in the detailed grounds. Paragraph 20.4 it seems to be an assertion that it's wrong in law to conclude that there are circumstances in which accountants aren't responsible for a particular error. Well, that can't be right. There may be some circumstances where they're responsible and others where they're not.
Well, maybe, yes. It's a fact-by-fact analysis.
It's an assertion which is just too broad.
Well, the Secretary of State's position in the refusal letters was that it was simply not credible that an accountant would make an error of this nature.
Yes.
That was something that was treated by Mr. Justice Martin Spencer and Khan as being, just as Milady said.
It might be, but it's a triple error. They asked to explain it twice, and all they say is, spread check, we told to write this with the instructions of the client. Is it irrational to take
And then we didn't reconcile the bank statements, which wouldn't have shown the cash payments necessarily.
So, is it irrationality? Anyway, you've heard anything more to say about that?
Not in respect to that particular sub-paragraph, my Lord. I mean, as I say, I indicated that paragraph 20 sets out in reality all that I wish to say. So perhaps just keeping an eye on time.
Well, we'll just work our way through that and see whether it's truly irrational or whether you're simply saying you disagree with it. Yep.
My Lord, yes.
Yep. Okay. So that's ground two then. It is really everything in paragraph 20 is your ground two, really.
That is, and perhaps just briefly, if I may, dealing... the Court will have noticed the Secretary of State seeks to amend the position that was taken in Balajigari, where the Court of Appeal indicated on concession by the Secretary of State that dishonesty is required in earnings discrepancy.
At the moment, we don't think we need to go down the route of the various forms of... We understand why Miss Apps did it in the light of the terms on which permission was granted, but this letter is clearly on the basis that your client is dishonest. It says so at page...
Precisely my point, my Lord. I accept that.
So
Yeah.
other potential forms of dishonesty are not relevant on the facts, so we just
Yeah.
don't need to deal with them.
My Lord, yes, not
It's not a criticism, perhaps. We understand why you did it and you worried about other cases. But here it said you're dishonest, the income was not legitimately earned, it's considered your income was falsely inflated. And there can't be any sort of turning a blind eye or anything like that. So I wouldn't worry about that for the moment, yeah.
My Lord, I'm grateful. That then only leaves me with
Ground three.
Ground three. Ground three is, as I say, the fallback position, even if the Secretary of State was entitled to reach a conclusion on dishonesty. Ultimately, the length of leave was granted. There are two rules that are in place.
Yeah.
We've got paragraph 3225 and then we've got paragraph
Yeah.
276B. If we take them separately, the wording of paragraph 3225, which Millen Friends very helpfully has printed off, but
Yeah.
I think the court will be familiar with the requirements under the law, talk about presence in the United Kingdom.
Yeah.
They don't talk about the length of leave. They talk about the physical being
Yeah.
of this migrant in the United Kingdom, notwithstanding the character and conduct issues in question. Where, as we say, Balajagari has confirmed, and I won't trouble the court given the time to turn up the relevant paragraphs, the two-stage test that is well known. The question of whether there has been undesirable conduct, which we're no longer dealing with on this ground, and then subsequently the question of discretion. If there is a tick on reprehensible conduct or character and conduct, and we move on to the second strand of paragraph 3225, if discretion is to be exercised, then it's arguable in my submission, or more so than that, given where we are in this litigation, that paragraph 3225, as a standalone provision of the rules,
Can't you say his presence is undesirable? We wish we could get rid of him.
But we
He
can't
lied,
because
but
he's
we
got
can't.
children.
He's got two children. Sorry, my lady, like a Greek chorus.
well, that is where we come on to also paragraph 276B, which
Yeah.
features in the authorities bundle towards the very tail end.
Yeah.
That, of course, has, as we know from the authorities, a different test and is treated as being a separate provision. I think this is page 1110
Yeah.
of the authorities bundle, so right at the end of tab 2. 276B contains within it subparagraph 2, or Roman 2, the requirements that are to be met, and includes that there are no reasons why it would be undesirable for the applicant to be given indefinite leave to remain. And then it sets out within it a series of 6 factors which need to be considered. Some of those we don't need to trouble ourselves with, such as age. The wording of 276B has been the subject of criticism because it, and I'll take the court to the authority in question in a moment, touches upon the fact that it is worded too strictly where it is said that there are to be no reasons why an individual, why it would be undesirable to grant leave to remain. The ultimate position that the appellant takes in this context is that this is a balancing exercise which requires a consideration of a number of factors, and it is to a certain extent open-ended. We have age, not relevant, strength of connections, well, he's got his family here, and that is the basis upon which leave is ultimately being granted on the road. Character and conduct, we're proceeding on the basis that the Secretary of State is correct.
Correct on this case, yes.
Indeed, domestic circumstances, well, that, again, family, compassionate circumstances, and any representations made. Insofar as the authorities are concerned, dealing first with the concern about the wording of paragraph 276B, if we can go to tab 2 of the authorities.
Can I just get, before we go to the tab, what is your submission on this case? How do you say that you can't reach a decision under 276B which involves refusing indefinite leave?
Firstly, there's 2 prongs to this complaint. Firstly, the Secretary of State hasn't conducted a full balance.
Yes, that's the first point, yes.
And secondly, which is where both Barbican, the authority in question, and also Goronovsky, albeit on different regimes I accept, bite, is that there hasn't been a consideration of the foreseeability of removal, given the circumstances in this case.
Why is that relevant? Under 276B?
That, the appellant would say, would would really fall into 276B Roman 2E/F. The question of removal. It's clear that 276B has been.
Well, it's not a compassionate circumstance. They can't get rid of him. They'd like to, but he's got children.
A question has to arise, my lord. If
He gets 30 months because he's got children. Why should he get more? Is what the Secretary of State said.
Why shouldn't the Secretary of State be entitled to review it on a regular basis to see how he's ticking along?
Well, I think the same similar provisions apply to what was seen by the upper tribunal in Goranovsky. The question of removal is, in my submission, so far removed, it's exceptionally unlikely on the facts as they
That's for
currently
the Secretary of
stand.
State. It's not for us. That's not an irrational. Unless you're saying it's irrational, or there's a failure to have regard to it, or that the rules don't allow it. Because you or I would take a different view and say, oh, yeah, he shouldn't have done it. She's got kids. Let's draw a veil over it. Unless it's irrational to do anything other than that.
Well, if we take
How's
stock,
it a legal ground?
if we take stock of where we are, my lord, as I say, assuming for the sake of argument that the Secretary of State's allegations are ones that she was entitled to.
Yeah, assuming that, otherwise we don't get there.
Indeed.
Yeah.
He's amassed 10 years of lawful residence. So that is
Well,
an issue.
but has he? Has he? I mean, some of that was based on things that he said were untrue.
And does it matter anyway? Because it's two that's the problem.
Insofar as my lady's question is concerned, I think I have to go back and refresh my mind as to the definition of lawful residence, but I think that is limited in its definition under paragraph 270.
Well, he might have had leave on paper, but as a result of everything that the Secretary of State has discovered subsequently, why isn't she entitled to it? He might have had leave on paper, but what the paper is written on?
But anyway, she hasn't done that, and that's not where we are. But so why under 2? I mean, I don't understand why under 2 she can't say, well, I've looked at all of these things. I wish I could get rid of you tomorrow, but I can't, because there are children. But I'm not going to give you something you shouldn't have. But I'll give you something because of the children. And of course, I'll have to look at things. If the children leave, if you split with your wife and you never see your children again, I don't want to keep people in the United Kingdom on this hypothesis who constantly forge their tax returns or inflate their Home Office returns or whatever it is.
My lord, I'll pitch my submission in this way, if I may. If we draw a comparison with the nationality guidance and good character requirements, the Secretary of State is entitled to refuse if there are concerns about good character. But there is an end point defined within statute where a particular type of conviction or a particular type of poor conduct is no longer something that adversely attaches to the application.
He's not applying for citizenship, he's applying for
No.
leave.
And I appreciate that.
276B. Yeah.
And I appreciate that, my lord. But the point made is there is no end in sight here. Now, the
That's his
Secretary
own
of
fault.
State's
If
case-
the end would have been in sight if he hadn't, on this hypothesis, inflated his earnings. And he needn't worry about that because it's his own fault. He shouldn't be here in the first place because he wouldn't have leave.
Well,
No, he's got children, and you've got to think about the children. So, I don't understand the submission at the moment.
Well, I think the foreseeability of removal, it encompasses a number
He's got no right to be here unless he gets leave. He is not a British national, therefore he needs leave. The Secretary says, I wouldn't give you leave. Not really going around inflating your figures to try and pull the wool over my eyes. Now, you've got children. I've got to be reasonable. Look at the children. I'll give you something because of the children. Now, where's the error in that? The error in that is only because you are assuming he's got to have something and he's got to have an end point. And the answer is, where is the obligation to have something and have an end point?
Well, my lord, I think in concluding my submissions on the point, it's simply going back to the authorities that have been touched upon in my skeleton argument, Goranovsky in particular.
Well, should we do those after lunch then? I think we'll have to do that. If this is an important, if there's a real legal point that there is an error of law in refusing somebody leave indefinitely because the Secretary of State, although she doesn't think you should have it, is boxed into a corner because she's worried about the children and says, well, you've got to have something for the children. Therefore, it's unlawful to say you must have it forever.
I'm content to proceed with
So
that.
shall we do
after
that at
the
2
short
o'clock
term,
then?
Just if it assists, it probably won't be more than 5 or 10 minutes in terms of the time marker for my learned friend submissions.
And Ms. Apps, you've heard that we are understanding of why you dealt with your tripartite analysis of dishonesty. But as you can see, we're not currently minded to go down that route because this case seems to have been decided on the basis of clear findings of dishonesty. And the real question is, were they unfair? Were they irrational? And even if they weren't, should you not have granted him indefinite leave anyway, because you couldn't remove him because of the children?
My Lord, I have heard that and understand.
Great.
I might say something very, very short about the extent of the concession, but I will keep it very, very
Yep.
brief.
Yes, because we don't want to spend too much time on things that don't arise. Right, well, 2 o'clock then.